Section 4, entitled Method of Elections, but it says nothing of the sort. To the contrary, that article expressly gives the legislature plenary power to prescribe the permissible methods of election, subject to only one proviso, and that proviso is that secrecy in voting must be preserved. And of course, this court may well recall that it addressed the secrecy in voting provision with specific respect to Act 77 in the 2020 case of Pennsylvania Democratic Party, and the court held, I think clearly informed by that constitutional requirement of secrecy, that the Act 77's requirement, which said that ballots returned by mail had to be enclosed in a secrecy envelope, that was mandatory, and that any ballots that did not comply with that requirement must be set aside and not counted. So petitioners also look now to Article 7, Section 14 for the prohibition that they say exists. But the plain language of that section requires the legislature to allow certain types of persons to vote absentee. It says the legislature shall provide those groups the ability to vote by absentee ballots. So in other words, it sets a floor of constitutional rights that the legislature cannot take away for the people who fall into that category. It does not prohibit the legislature from allowing others to vote by mail. Now finally, petitioners rely on Article 7, Section 1, and that's really the primary basis for their argument. But that section, by its clear terms, is expressly addressed to voter qualifications. In other words, it talks about who may vote, not how they may vote. It imposes residency requirements that citizens must meet in order to be eligible to vote. So first, they have to be a resident of Pennsylvania, and they also have to be a resident of a particular election district. Now, which election district? Well, the provision tells us it's the election district in which they offer to vote. So the provision says you've got to be a resident of the election district in which you want to cast your ballot. So as a member of, or as a citizen resident of Philadelphia, I can't vote for the mayor of Harrisburg, and indeed, I can't vote for the judge of elections of a different election district than the one in which I'm a resident. That's all it says.
Counsel, can I ask you about that, just that language? What's the difference between you voting in Philadelphia and you offering to vote in Philadelphia?
Well, Your Honor, I think offer to vote clearly by its terms suggests that I'm making an attempt, which could be accepted or rejected, right? So I can offer to vote by submitting my ballot, and indeed, under Act 77, the method is more expansive, right? I've got to start by registering, and then I've got to apply for a ballot, and then I have to receive it, and then I have to return it, and then everything that I've done will be evaluated by election officials, and they will determine whether what I've done complies with the requirements, and therefore whether that offer will be accepted or rejected.
Is it to be traced to a sort of an antiquarian setting, that the kind of thing Justice Woodward was talking about back during the Civil War, people seeing you show up to vote and they could question who you were?
Your Honor, there's nothing in the term offer to vote. We submit there was nothing in the term offer to vote in 1838, and that's clearly reflected, we think, by the legislative history. It's certainly not, and the bulk of the case law, we think, supports our position. The term offer to vote, even read in isolation, doesn't support petitioner's argument. It certainly doesn't plainly, clearly, and palpably.
And was Chase and then Lancaster, which was premised upon Chase, wrongly decided, distinguishable, or what do we do with it?
Your Honor, we think it's distinguishable, and so we don't think the court needs to overrule them. But if the court disagrees with us on their distinguishability, yes, we think they were wrongly decided at the time, and Mr. Waxman is going to address this in more length, but just by way of introduction, they were wrongly decided at the time. They're even more irreconcilable with the current Constitution, the current standards of constitutional interpretation, and so if necessary, they should be overruled. But we do think that they're distinguishable, and if I may, I think I'd like to start to address Chase in particular. So Chase is distinguishable for two major reasons. One, it interpreted materially different provisions of the 1838 Constitution as opposed to the current Constitution. And two, the scheme of voting at issue in Chase is nothing like the system of voting, the method of voting set forth in Act 77. And I want to start with that because I think it clearly underscores why Chase is an apposite. The system of voting in Chase, right, was a system in which elections were allowed to be conducted. Essentially, military commanders, who might not even have been Pennsylvanians, were allowed to set up election districts in military camps outside of Pennsylvania, even on the battlefront, and hold elections with no Pennsylvania civil authorities to supervise, with no means of determining whether the people who were voting were even qualified Pennsylvania electors. And I think if you read some of the prologue of that opinion, there's a question of how do we know whether these votes were even cast by Pennsylvanians? We're going to rely on a stipulation so we can get to the legal meat of the case. But completely different than Act 77, and I think the court understandably ruled that scheme of wholesale delegation of civil election authority to military officials who were not even Pennsylvanians was itself enough to invalidate the statute.
Would you, in furtherance of that, and alluding back, I think, to an answer to Justice Weck, if the military commander sets up a Pennsylvania voting booth, and the military commander's from Illinois and doesn't even know where Pennsylvania is it under the law that Chase was scrutinizing, would a Pittsburgher be able to vote for an Erie city councilman, and would an Erie city councilman be able to vote for a Philadelphia mayor?
Well, under Section 1, even at the time, that was prohibited, right, because of the residency requirement that I talked about. But I think Chase's concern was, given the statute at issue, there was no way of policing even that requirement, right? That was what Chase was concerned with. But one of the points I want to make is that Chase is addressing whether, say, any mail-in voting would be permissible. We believe that's dicta because Chase, we think the holding was that the Constitution recognized election districts as among the civil institutions of the state, and I'm quoting from the opinion now, to be created and controlled exclusively by the civil as opposed to the military power, and that the civil power cannot commit the formation of election districts to the military. So that was more than sufficient basis to dispose of that case. Now, the court also went on to discuss the offer to vote language, but that was not necessary to the holding. But even if you look at that dicta for what it is, we think it's clearly distinguishable from the current Constitution because Chase looked not at offer to vote in isolation, not at just that what was then Section 1 of an elections article, that's Article 3 of the 1838 Constitution, that is completely different than what is now Article 7, right? Article 3 had only 3 provisions, qualifications in Section 1, Section 2, which didn't provide the legislature with any discretion to prescribe the method of voting, and then a Section 3 that said you couldn't be arrested when you're going to vote. That's it. Current Constitution, by contrast, has 14 different provisions in its elections article. And crucially—
Yeah, but counsel, none of those, since Chase, the Constitution has been amended several times. And not once did the framers or the voters remove the offer to vote language, which was clearly interpreted by the court in Chase. And if anybody wanted to do that, wouldn't that be the clearest intent of wanting to change or react to Chase by changing the offer to vote language instead of adding other provisions that don't cut against that interpretation in Chase?
Well, Your Honor, I think there are a couple of responses to that. First of all, Chase relied not just on offer to vote for its interpretation, but also what was then Section 2, which was a provision that, as I mentioned, only gave or didn't give the legislature any discretion over the method of voting. And that was diametrically changed in 1901.
So are you saying that was an implicit, by adding that in 1901, that additional discretion to provide for a method other than by ballot, that was an implicit repealer of the offer to vote language?
Your Honor, I think it clearly distinguishes Chase's holding under the 1838 Constitution.
So you're not arguing it was an implicit repealer. You're arguing that because of that change, we should interpret offer to vote differently.
Well, Your Honor, I don't think the question of whether it's an implicit repealer is the question that really is dispositive here. I think the question is whether the current Constitution before the court, interpreted as an integrated whole as it must be, the modern Constitution, the Constitution of 1968, clearly, palpably, and plainly prohibits mail-in voting. And I think I would also mention that not only do we think the interpretation of offer to vote was wrong on its own terms in 1838 and dicta beyond that, and then further distinguished by an alteration of one of the key provisions that Chase relied on for its interpretation. But the basic policy, well, the basic rationale that led Chase to strain to read in a prohibition on mail-in voting or a requirement of in-person voting into that decision no longer exists. So it's clear if you look at the Chase opinion, what the court was concerned about was that if you didn't have in-person voting, you would have no means of verifying the qualifications of electors. And that was probably true as a matter of social fact at the time, right? Chase talks about the need for one to vote alongside one's neighbors so that one's neighbors can either confirm or dispute your identity and your qualifications to vote. Now that's an atextual requirement, and we don't think that appears in the Constitution, but it's understandable that the court was concerned about that at the time. But that system of voting, or the need for that kind of in-person verification, it's completely eroded over time, right? So in 1901, not only do we have the introduction of the method provision that currently exists in the Constitution, but we also have an amendment to that qualifications, section 1, the article, and it's amended to allow the legislature to impose registration requirements. And that's important because as you move into the 20th century, and certainly by the time you get to the 21st century, you have a very sophisticated system of registration that grows up. And that means well before you get to the polls, a voter has to prove their qualifications to vote by submitting evidence that's evaluated. And in fact, the election code allows people to challenge someone's right to be registered.
Is that
to
the
vote.
offer to vote? Is that an offer to vote, the registration?
Your Honor, I think you could understand that as part of the process of offering to vote. I think you absolutely could.
How do you construe offer to vote in today's world?
I think it means that you are nothing more than that you are seeking or proposing to vote. In other words, the reason you needed the offer to vote language is you had to have some way of specifying which election district one needed to be a resident of, right? And so you've got to be a resident of the election district in which you're seeking to vote, not some other election district.
But to seek or propose, indicates that you have to do something affirmatively. So what is that something?
Yes, so clearly under the current Constitution, the current electoral regime, you've got to register. If you're voting absentee or by mail-in, then you've got to apply for a ballot, in which case you have to prove your identification once again, and that has to be verified, and it can be challenged, again, all prior to Election Day. And then you have to cast a vote, and of course, if you vote in person, you've got to register, and then you have to go and register, and then attempt to vote. And of course, at any point in that process, if the election officials find that you haven't complied with the authorities, that offer will be rejected, right? But we think the case law is, I'm sorry, Chief Justice Barrett.
Go ahead and finish.
So the case law nationwide, right, offer to vote, the point I want to make is not in any way unique to the Pennsylvania Constitution. It appears in lots of different constitutions and has over the years, and we've cited to you a lot of the authority interpreting that provision, and the vast majority of it reads it just as we do. It is something that can be done in writing. It can be done by mail. There's nothing about an offer to vote that requires it to be in
May I
person.
turn your attention just back for a second before your time expires to Article 7, Section 14. You sort of slid by just saying, well, it's obviously a floor. But it can be read as a floor. It can also be read as the ceiling. Is there anything that you've discovered that informs or elucidates that it was intended as the floor rather than the ceiling?
I think I'd point to at least two things, Your Honor. One is the fact that the language was changed from may to shall, right? It's not that we're just looking at a provision that said shall and has always said shall and trying to figure out what it means. I think it's important that there was a change made in 1967 after Lancaster City for the sole purpose of changing may to shall. That, if you look at the legislative history, that was the sole purpose of that amendment. And the legislative history certainly suggests that the reason for that change was because there had been a complete shift in attitude toward voting between Chase and 1967, right? Chase really celebrated the fact that at the time, the Constitution only allowed white freemen who paid taxes to vote, and that excluded 80% of the population from suffrage. By the time we get to 1967, the basic attitude of the Constitution toward voting is fundamentally different, and the legislative history reflects that amendment was animated by the spirit of making voting rights protected, and because they were so fundamental because they were understood to be protective of all other rights.
Counsel, in that regard, how do you address Rizzo versus Board of Elections, which specifically held that shall implies a ceiling, not a floor?
Well, Your Honor, I think in certain contexts it can. I mean, these are all context-dependent issues, but I think in the context of Article 7, in the context of the legislative history that we have, it does not. We think it clearly does not, but at the end of the day, it's petitioner's burden to show that it clearly does. And we think there's no way that they can show that.
So it's ambiguous in that.
I think at best for petitioners, it's ambiguous. We think, given the legislative history and given the change from may to shall, and I would add one other point. It's not just my interpretation of may to shall, it's also the legislature's interpretation, because as we showed, coincident with the change from may to shall in 1967, the legislature allowed categories of persons not within the groups defined in Article 7, Section 14, to vote absentee, and that included anyone who was on vacation. And that's a fairly significant exception, because the constitutional article only allows, in pertinent part, people whose work duties require them to be out of town.
Well, why just because the General Assembly has allowed it, does that influence our interpretation of the may to shall? Because those statutes may be unconstitutional as well. They're just not challenged in front of us right now.
Well, Your Honor, I think the contemporaneous interpretation of the legislature is an important piece of evidence of what the common understanding of that constitutional meaning was at the time, and the court has looked to contemporaneous legislative interpretation to glean constitutional meaning. And I think, indeed, that was one of the flaws in our view of the Chase opinion, is that at the time of Chase, right after the 1838 Constitution was enacted, the legislature reenacted this method allowing soldiers to vote outside of their district, which I would think is powerful evidence of how offer to vote should or should not be understood, and Chase just brushed that aside in favor of its own interpretation.
Counsel, can I get back to Justice Todd's question for a moment? The context that she was looking for in Act 77 and the offer to vote language. A majority of this court held back in the 2020 election cycle, at least I think it could be argued, that the offer to vote is putting the ballot in the mail, because the majority of this court held that that was sort of the key timing point in the context of whether or not a ballot was timely. Is that accurate? Is that the way that we should look at what offer to vote means? You put it in the mail?
Your Honor, I think that's a perfectly reasonable interpretation of how it would apply here. I guess I would say, I think the only question this court has to answer for purposes of deciding this case is, does offer to vote require manual in-person submission of the ballot? But I think that the interpretation Your Honor has just suggested is also consistent with the interpretation of other courts, like the Jenkins Court in North Carolina, that said an offer to vote can be made in writing, it can be made by mail, and that's...
I'm just trying to get context.
Yeah.
I like to have context when I'm trying to work these things out. I mean, when Justice Todd asked her question, you started talking about registration and asking for a mail-in ballot. Why are you looking at that? Isn't the offer to vote tied to the concept of casting a vote?
Your Honor, I think
to
that's
preliminaries there too.
Yeah, I think that's a very reasonable reading of it. I don't have any dispute with that, and I agree with Your Honor that does seem to be the reading that this court suggested in its 2020 opinion. For me, what is crystal clear is that there is nothing in the term offer to vote taken alone, and certainly not in context, that requires in-person voting. And indeed, to come back to the context, Article 1 is about the qualifications of voters, right? Not about how they vote. And petitioner's interpretation of the Constitution would say that the legislature was granted vast discretionary authority to prescribe the methods of voting in a methods section of the Constitution, and then that authority was largely gutted in a tertiary sub-provision of a clause addressed to voter qualifications without any acknowledgement in the Constitution that that's what it was doing.
Well, in fairness, the offer to vote language appeared in the Constitution before the authority was given to the General Assembly, so it's really the reverse. You're suggesting that the addition of the discretion to the General Assembly gutted the offer to vote requirement interpreted by the court in Chase. And the method language you're also relying on was in the Constitution at the time the City of Lancaster decision was decided.
Your Honor, that is true, although one of the problems with the Lancaster City's decision, as we point out, is that it doesn't engage with that change at all, and it doesn't grapple with the fact that Chase expressly rested.
I understand you don't. I understand you don't like the decisions. I get it, but your arguments don't seem to be any different than I could imagine the lawyers making at the time the City of Lancaster was decided and at the time Chase was decided. Your arguments are probably no different, and you're just asking us to revisit what provisions in the Constitution have been for a long time, with the enlightenment of being here in 2022 versus what the justices had a mere 20-some years after the offer to vote language was put in the Constitution. Why are we so much more enlightened today than the justices were then?
Your Honor, I would characterize what we're asking the court to do a bit differently. I think we're asking the court to look at the current Constitution and read all of its provisions together harmoniously and decide whether there is a clear, palpable, and plain prohibition on mail-in voting. And we think that, yes, we understand we need to address Chase and Lancaster City, but they were decided under other constitutions, and we think that they are distinguishable. And we think that in each case, not only are those decisions flawed on their own terms, but they rested on provisions of the Constitution that no longer exist at all or have been fundamentally altered. The provision that that Lancaster City rested on, which was an amendment that was enacted in 1864 for the express purpose of overturning the Chase decision. And Lancaster City, rather puzzlingly, I think, decided to view that amendment, which had the purpose and effect of nullifying Chase, as limiting the legislature's power to allow other groups of people to vote absentee. But that provision was repealed in its entirety in 1967, coincident with the introduction of what is now Article 7, Section 14. And in addition, not only are the constitutional provisions very different, but the schemes of voting at issue are very different. And if I could put a point on this, I mentioned the introduction of registration requirements, especially as we get into the 20th century. There's a decision by this court, which isn't cited in our papers, from 1938 called In Re General Election in City and County of Philadelphia on November 8th, 1938. That's reported at 2A 2nd 301. And that case is really the mirror opposite of Chase in some ways, right? Chase said we can't verify the qualifications of voters unless they show up in person so their neighbors can say, yes, this is John Smith, or no, it's not. In the 1938 case, someone who I think was a chief party official in Philadelphia was going to go and vote, but there was a problem. His registration papers weren't in order. And this court said, well, then you can't vote. Right? It doesn't matter that you're going to go and vote in person and everyone can say, yes, I know you, you're a prominent leader in the community. You haven't complied with the registration requirements, and you've got to go to the Court of Common Pleas and get that sorted out and prove that you have in fact registered. Right? So we've come so far from the concerns animating Chase by the time we get to 1938 that the court has realized that we verify voter qualifications well in advance of when someone actually goes to the polls and casts their ballot. So the basic, even if you put aside the atextual nature of Chase's construction of offer to vote together with Section 2, even if you put aside its conflict with the legislative history of the 1838 Constitution, even if you accept that the essentially policy concerns that animated the court should be given weight, those policy concerns are gone, certainly by the time you get to 1938. And now in the 21st century, we have a computerized registration system. We have the SURE system, which is a computerized database that contains the registration information for all voters in the Commonwealth, and it can be accessed by all the election officials, and it's kept up to date, and it's contemporaneous.
Mr. Weigel, before you conclude, Justice Todd's been trying to ask a question for about 20 minutes.
I'm sorry, Your Honor.
That's all right.
No, that's fine. If we were to find, Mr. Weigel, that there's an ambiguity in our interpretation of the may to shall language or in any other respect, what would you have us do?
If there is an ambiguity, I think this court's precedent, and Your Honor's opinion for the court in Stilp, is very clear. It's that all doubts as to the constitutionality of a statute have to be resolved in favor of the General Assembly's authority. And I would say, if anything, that principle applies with more force here, because there's no allegation that Act 77 is violating any individual right in Section 1, Article 1 of the Constitution. There's no allegation that it imperils the separation of powers between the coordinate branches. So we don't dispute that if there were a clear, plain, and palpable prohibition, it would have to be given effect. But if this court has any doubt about that, the precedent is clear and the statute must be upheld.
Certain irony in the fact that 13 legislators are attacking the statute, that the presumption that what they did when they voted for it is constitutional could doom them. It's interesting. We'll have to ask the other side about that, but it's interesting.
Counsel, can I just follow up on Lancaster, which I frankly think is your bigger problem than Chase. The Lancaster City Court, in fact, considered Section 4 in rendering its decision, and essentially said, yeah, we see Section 4, which allows the General Assembly to control the method by which the vote will be taken. However, whatever they do under that section is subordinate to the court's holding in Chase that interpreted offer to vote. Now, granted, there's no discussion why that would be so, but how do you reconcile the fact that what you're arguing now that, well, in Chase they didn't have Article 4 and that makes a difference, when in Lancaster City there was Section 4 and they subordinated it to Section 1?
Your Honor, I give two responses to that. First, with respect to Section 4, it's true that the Lancaster City Court acknowledged the existence of that section. I'm not sure I would go so far as to say that they made a conscious decision that it should be subordinated. Clearly, they did subordinate it as a matter of fact, but there was no analysis, right? There was no analysis of how Chase's construction of Article 1 and Article 2 together could be reconciled with the fact that Article 2 of the 1838 Constitution had been completely transformed.
Well, they did consider it, but you're right, there's no analysis. But that would go to whether or not, or what, if any, stare decisis effect is given to a holding such as this when there is no analysis.
Your Honor, that the court could certainly choose to see it that way. I think
we'll hear about that.
I think that there is also precedent that stands for the proposition that where there is a point that is simply not addressed by the court, and indeed there's no evidence that it was ever argued in an adversarial fashion before the court.
I don't know how you say that. I mean, the opinion sets out further it is provided by Section 4, colon, and then it has Section 4. And then the next sentence is, it will be noticed that the offer to vote must still be in the district where the elector resides, and then it goes on to say, as was eloquently discussed by Justice Woodward in Chase, goes through the offer to vote language. I mean, there's no connecting thought process between those two things, but I mean, to say they didn't consider it would be probably unfair to at least the way it appears on paper.
Well, let me then address my second point, Your Honor. Maybe this will be more responsive, because again, I think the question is whether this court should view that decision under the 1874 Constitution to control the issue before the court now with respect to Act 77 and the 1968 Constitution.
And that's a good question. Why wouldn't we?
Well, not only do we have the problem with the complete lack of analysis, but we also have the fact that Lancaster City, I think in the end, for all of the block quoting and discussion and praise of Justice Woodward's decision in Chase, in the end, I read that opinion as resting on the 1864 amendment, and the court applied the canon of expressio unius, right? It said, well, 1864 gave permission for the legislature to allow soldiers to vote. It didn't address other people, so we think that's an implicit prohibition on allowing other people to vote. That was insofar as there is a logic or rationale of the decision, I think that's it. And as I mentioned, that amendment, and I think that's, again, a puzzling way of reading that amendment, given that its purpose was to overrule Chase. Putting that aside, that amendment was repealed in its entirety in 1967, and what took its place is what is now Section 14, which again mandates, does not permit, it mandates the legislature to allow certain people to vote. The expressio unius canon, that logic, doesn't apply in the same way there, right? The expressio unius logic, if applied to what is now Article 14, would just mean that the legislature isn't required to allow anyone else to vote. But it doesn't say anything about whether they are permitted to allow others to vote by mail.
And let me follow up on that, because people who vote by mail are not absentee voters necessarily.
That's right, Your Honor.
They may in fact be, most in fact are, likely in the district on election day. So, you know, it's hard for me to grapple with the concept that that section of the Constitution deals with voters who are not absentees, who are not absent from the district.
I think that's a very important point, and I think therefore even if you were to conclude that even with the change to may to shall, Article 14 was necessarily a ceiling on who could vote absentee, which again I don't think is a defensible position, it would not speak to people who aren't voting absentee, and I think that Judge Wojcik made this point in his dissent, and it's an important one, and I think, if I could just underscore it, particularly given that for the entire life of the current Constitution, anyone who's on vacation can vote absentee, right? That basically means, I mean, maybe I'm missing something, but I think that means essentially anyone who's out of town can vote absentee. You're either, you know, out of town for work or some duty necessity, or you can argue you're on vacation. And so the only people who couldn't vote by mail would be people who were still at home in their election district. And Act 77 corrected that imbalance. I think that's one way one could certainly look at it. But I agree with Your Honor that Act 77's, certainly the primary effect of that statute was not anything to do with absentee voters at all. It had to do with how people, most of whom were voting from the comfort and safety of their home.
But it doesn't have to be to correct any imbalance, right? I mean, your position is the legislature had plenary authority.
Correct. We think the legislature always had the authority to do this, notwithstanding the decisions in Chase and Lancaster City because of problems with those decisions.
Well,
but certainly it doesn't.
They thought they did too until they didn't.
Exactly, Your Honor. And indeed, an overwhelming majority of the legislature enacted Act 77, including most of the petitioners before this court, right? And so the only inference this court can draw from that is that the legislature thought in 2019 that it had the power to do this.
Well, I'm not sure you can draw that inference if there's precedent that says that. I'd be interested to see it. But, you know, I'm not, your argument seems to be if it's a popular or unanimous law, it has a better chance of withstanding constitutional scrutiny. And this court recently found unconstitutional Marcy's law, which was voted by a majority of Pennsylvanians as an amendment to the Constitution. So I'm not sure why overwhelming support by the legislature deserves some sort of deference in terms of our constitutional analysis, and you're not suggesting that, are you?
I am not, Your Honor, and if that's how it came across, I want to correct the record. The popularity of the policy, or the wisdom of the policy, or its lack of wisdom for that matter, have nothing to do with the constitutional question before the court.
On the other hand, what our legislature does in the first instance is entitled to our recognition as presumptively constitutional.
Absolutely, Your Honor, and the point to return to...
And that was the point I was making, not that it was popular.
Absolutely, and to return to Justice Robson's point, I was really addressing an argument on the other side, which is that there was discussion in 2019 also about a possible constitutional amendment, and that in and of itself should somehow give weight to the notion that it was required, when obviously the General Assembly ultimately drew a different conclusion. Your Honor, if I may just conclude. I want to return to Justice Todd's opinion for the court in Stilt, because I think that's really, in terms of the standard this court should apply, the most important precedent. And the court there said, the Constitution has given us a list of the things which the legislature may not do. If we extend that list, we alter the instrument, we become ourselves the aggressors, and violate both the letter and spirit of the organic law as grossly as the legislature possibly could. I respectfully submit petitioners here are asking this court to extend that list and to do so by taking away Pennsylvanians' statutory voting rights. And appellants respectfully request that the petitions for review be dismissed and that the Commonwealth Court's decision be reversed or vacated. Thank you.
Thank you very much. Mr. Waxman? My recollection is you were here some years ago on
You have a
voting
good-
rights.
You have a good recollection.
It's nice to see you
And,
again.
you know, I have to say that having come back now after several years, this courtroom is just as amazingly impressive as it seemed to me when I was considerably younger. It's an honor to be here, and I do have with me at council table Mr. Cliff Levine and my partner Daniel Volchuk. I'm very mindful, Chief Justice Baer, of the admonition that I am not to tread prior ground, and I, of course, welcome an admonition if I do appear to be saying anything that bears on what Mr. Weigel said. As he indicated, what we had decided in an effort not to repeat each other, or for me not to repeat him, is that I would explain to the court why, if Chase and/or Lancaster City cannot be distinguished, they should be overruled. It's many of the reasons why they should be distinguished, and are the same reasons why they shouldn't be given stare decisis precedent. So I apologize in advance if it appears that I'm inching over ground that was already covered. I also will address very briefly the claims of federal unconstitutionality, and of course, I'd be happy to answer any questions that the court has. I mean, if Chase or Lancaster City do somehow control this case, the outcome in this case, and I could not agree more that they were interpreting extraordinarily different constitutions and extraordinarily different methods of voting that was an issue in either of those cases. If you nonetheless conclude that they can't be distinguished, then they certainly should be overruled. I mean, the reasoning, I will talk about the reliance interest, which of course is an important consideration, and also mention the fact that there is a non-severability provision in Article 77, in Act 77, which was a very wide-ranging law that enacted many, many changes in the election code, including the prohibition of, block party voting. All of that would have to be struck down. I'll address those sort of non-substantive reasons why they should be overruled if they otherwise would preclude reversal. But the main point, I think, is that the reasoning in both opinions was weak and utterly unpersuasive in light of developments, both constitutional and statutory, over the intervening 100 or 150 years. As to Chase, the relevant passage in Chase about what the meaning of offer to vote by ballot must have meant in 1938 is plainly dicta in that opinion. The opinion goes on for 7 pages to explain why this sort of rump session by which commanders someplace in the United States had A, no authority to establish a district, B, no means of providing any sort of civil authority over the conduct of the election, no means whatsoever to ascertain whether the soldiers who were voting were in fact residents in whatever district they were purporting to vote, or even whether they were Pennsylvanians. And that was the holding of the court in Chase. Now, the court in Chase did construe the words offer to vote by ballot in a way that, first of all, as the state's brief shows and the reply brief, and there doesn't seem to be any citation to the contrary by the other side, the history of the 1838 Constitution and what this provision was intended to do had zero, there's not one shred of any evidence whatsoever that it had anything to do with absentee voting, that is, voting by somebody who was a resident of the district in which he was offering to vote but wasn't there in person. Now, I acknowledge that Chief Justice Woodward for the court construed that. It's construed it to mean that way, but it is A, wrong, which is a darn good reason to overrule it if you have to. But in any event, and I'll say the same thing is true for Lancaster City, which I'll address separately in a moment, every single premise behind the reasoning of the Chase court for construing the terms offer to vote by ballot have evaporated. They no longer exist. Number one, the legislature, as of 1901, is specifically authorized to provide methods of voting other than personal presentment of a ballot in the district. Number two, the predicate of Chase was, the court said, and I'm quoting, "We cannot be persuaded that the Constitution ever contemplated any such mode of voting, such that to permit it would break down all safeguards of honest suffrage." That provision, that is, that it was necessary in order to determine that the white freeman who presented as eligible to vote was in fact a white freeman and was in fact recognized by his neighbors as a resident of that district. That is now a complete anachronism, to the point that the city of Philadelphia general election case that my friend cited to the court is now a 1938 holding by this court that the method of voting by ballot interpreted by Chase is actually not a permitted method of voting. The chair of the local Republican Party showed up in his polling place in Philadelphia, well known to everybody there, and he was told, under the 1937 election code, which implemented a universal mandatory registration system, which was constitutionally authorized by the 1901 Constitution's addition of the requirement of a registration system in what is now Section 1 of Article 7 itself. We recognize you. We know who you are. We know you live here. You cannot vote. You have presented yourself absolutely in the way that Chase in dicta said you are required to, but you can't vote because we don't have evidence of your registration.
Yeah, but counsel, they didn't the court didn't, and I haven't read that case, but I'm taking your representation as what it says. They didn't say you can go home and vote by mail. That decision doesn't sound contrary to Chase at all. Chase says you have to show up at the ballot in the district where you offer to vote. That voter did. The only reason was they weren't allowed to cast their ballot because they didn't satisfy some other registration process. But they didn't say you can vote by some other method.
Well, I'm not. I apologize for the fact that neither of us actually cited this case in our briefing in the case. I came across it in preparing for the argument today. But of course, it didn't involve the voter, the person who had been offering to vote, was not saying, I'll go home and vote by mail or something like that.
Well, and where it was turned away, he wasn't turned away because...
This is exactly the point. This is exactly my point. In Chase, the court said, look, we think offer to vote by ballot has to be read this way because two things are required in order to be able to vote. One, you have to be somebody who's qualified to vote. And that's, in fact, the title of what the relevant section of what was then Article 3 of the 1838 Constitution was.
I'm sorry.
No, I'm sorry. Maybe I was getting a little sidelined by in my answer to Justice Brobson. The point is that what the court said in Chase is we cannot permit individuals to vote, quote, where evidence of their qualifications is not at hand, and therefore they must present themselves in person so that they can be recognized by their neighbors. Now, at least since the 1937 election code registration requirement authorized by Article 7 of the Constitution since 1901, the qualifications are completely decoupled. And that's the import of the 1938 decision. The 1938 decision, basically, the guy was basically saying, I am showing up to vote just the way that Chase said that I can vote. And the court said, no, no, no. There are two things. There are qualifications and there's identification. The qualifications are for the registration system. And if you aren't registered, you can't show up, even if the poll officials recognize you and identify you as their next door neighbor. And therefore, just to get back to
Before you do that, I think Justice Dougherty had a...
oh, I'm sorry, that's right, Justice Dougherty.
I'm trying to understand the significance of 38 with Chase. As a former Philadelphia judge, that case, to me, developed the process for the Court of Common Pleas to sit on Election Day to entertain any challenges to one's qualification. And that would be it. Really, it's the process, and it was specifically included for Philadelphia only in that particular case.
Right.
So with that, challenging the qualifications to get what we now call provisional ballot, how is that in agreement or contradicting Chase's request that you have to vote in person, as
Right.
opposed to appear in person to prove your qualifications by a Court of Common Pleas?
So I think I sort of want to repeat aspects of your question back to you as the answer, but maybe it's, let me just say it. Chase said, offer to vote by ballot must mean that you have to physically present your ballot to the poll so that both your qualifications to vote and recognition of you as, in fact, somebody who's a resident of the district can be made. There is no other means of doing either. Now, after the in 1901, when the Constitution was amended to provide for registration, and when the 1937 election code was enacted requiring registration, this court in the City of Philadelphia case said, it is showing up and offering your ballot, even if you are recognized by everybody in the polling place, is not, as a resident, is not sufficient, because qualification to vote is set by registration. And therefore, the poll workers were correct in rejecting your ballot. On the other hand, if in fact you had registered and they just somehow didn't have you on the list, your remedy is to go to the Court of Common Pleas judge, who, by order is sitting from 7 a.m. to 10 p.m. on Election Day to adjudicate eligibility challenges. And if you can bring some evidence that you in fact did register, the Court of Common Pleas may deem you qualified and require that your vote be counted. But the point is that once there was constitutional authority to establish a registration system, and we don't have same-day registration, which is something that is done in advance, the time identity that Chase insisted on as a logical matter, in which the only way your qualifications could be ascertained and your identity could be confirmed was by showing up in the district. And that is no longer true. That has not been true
Counsel,
for 100 years.
I want to make sure I'm having a hard time following why this Philadelphia case is so significant.
Well,
are you suggesting, so let's assume, and I understand your side disagrees with the idea that Chase is more than dicta and offer to vote in the election district. Let's assume it means actually showing up in person to cast a ballot. Let's assume that for a minute. What is it about are you suggesting that because the General Assembly passed a law that addressed the reason why the court ruled the way it did, means that the way it interpreted the Constitution before the General Assembly enacted a registration law should now be discarded, and we should interpret it differently because the General Assembly, I'm just trying to understand, we should interpret the Constitution based on a General Assembly statute that supposedly remediated the basis for the original
No,
interpretation.
And I realize that I've gotten all excited here about the 1938 case only because it was a late discovery. To me, it's just the proof in the pudding that the meaning of offer to vote, I mean, the Chase court was construing offer to vote by ballot, but the meaning of offer to vote has not been implicitly repealed. It's there. It is the presentment of a vote for acceptance. You can present it by mail or you can present it in person, but it is accepted only if, and you know, this court's decision in the, I think it was the In Re November 3rd, 2020 opinion that if memory serves me, Justice Todd authored, basically said the qualifications are set in advance, and what is left for the canvassers and the poll workers is to ascertain that the ballot is in fact submitted by somebody who is the person who is qualified to vote, and that's done by all of the various information that's provided on the inner ballot. Our point is not that the 1938 case changed the meaning of offer to vote. Offer to vote by, what happened was not that the legislature subsequently enacted an election code that requires that you establish your qualifications in advance in a time and place that's different from the actual voting on election day. It's that the 1901 Constitution both authorized a different method of voting, authorized the legislature to provide other methods of voting, and that it provided for a registration system, which those two things together have created a method of voting. There is a method of voting that is specified in exquisite detail, and, well, maybe not sufficient detail in Act 77, since this court has had so many cases where it's been required to construe Act 77. But Act 77 is a method of voting. I think that this court's decision in the DNC versus, I'm forgetting the name of the secretary at the time, but the Democratic National Committee case, the naked ballots case, the challengers were basically saying that a ballot without the outside envelope is not, it cannot be allowed under the Constitution because the method of voting, they called it the scheme of voting or the system of voting under Act 77, it is a method of voting and therefore controlled by Article 4, Article 7, Section 4, where secrecy must be maintained. And this court agreed with the challengers and said, Act 77 is a method of voting, and under Section 4 of Article 7, the method of voting must be kept secret. And when you don't have the outside envelope, it's not secret, and therefore they can't be counted. So I think what is different is not that the legislature simply enacted a law. It's that it was authorized by the Constitution to provide for other methods of voting, including a method of voting that requires that you demonstrate your qualifications in advance through registration, and that method of voting is fully authorized by the 1968 Constitution and the Constitution of today as a constitutionally permitted method of voting. And it does not require, in response to the first question I think you asked of Mr. Weigel, it does not require any conclusion that the meaning of offer to vote has been implicitly repealed. It's that there is a method of voting that now manifestly not only doesn't require that you offer your vote in person in the district, but in fact, won't even permit you simply to offer your vote in person in the district. Now, I take to heart Justice Donahue's question about Lancaster City and your observation that this is the bigger problem. It's by far the shorter opinion. It's a pretty cursory opinion. You know, I would say, first of all, that Lancaster City relied utterly on Chase's reasoning without accounting. It recited the language of the 1901 Constitution, which included Section 4, and it actually recited the language of Section 4. Our submission is that it doesn't control because it didn't engage. There's no evidence that Section 4 was even argued. This was the argument in Lancaster City, and the opinion in the decision in Lancaster City was the legislature has offered another means of absentee voting. And the question is, I can't remember the number now, but what is now Section 14 of Article 7, does the fact that it then read the General Assembly may permit, serving military officers to vote absentee, does that leave the General Assembly authority to enact by legislation another means of absentee voting? And the court's decision turned on the justum generis principle, which it, may properly have applied to the word may at the time. And that was the basis for the decision. And so there is no account in Lancaster City either of the 1901 constitutional amendments that added Section 4's other methods of voting. And maybe it really wasn't an issue because I think, as Your Honor's question pointed out, voting by mail is a different method of voting than voting absentee. There's an amicus brief in this case filed by a coalition of disabled people who absolutely live in the district, but they can't go to the polling place, and they are now allowed to vote by mail. But even if you say, well, absentee voting, mail-in voting, it's sort of all the same thing. If you vote by absentee, you're voting by mail. They are not the same thing. But if you thought that Section 14 controlled, the version of Section 14 that Lancaster City was interpreting and applying the justum generis construction to is in the very most relevant part. It said that the legislature used the word may. That's permissive. And by having a constitutional provision that allows the legislature to do one thing, it is a fair reading of that language to say that the legislature is not allowed to do other things. We and the state have cited this court to decisions of this court saying that when you use the word shall, it is a mandate. It establishes a constitutional right in those categories of absentee voters to, in fact, vote absentee, which the General Assembly can never change. And that is not a limit on what the General Assembly does. Now, I will concede, I think this was Justice Weck's question, but I may be wrong. I will concede that in different contexts, the word shall can mean different things. And I'm going to give you a couple of examples. But the salient point here is if the word shall could mean, if this case were controlled by Section 14 of Article 7, and if it turned on the possible meaning of the word shall, the jump ball arrow is in our favor. It is the challenger's burden to prove that today's Constitution prohibits clearly, palpable, plainly, and beyond all doubt this method of voting. And so if it's a plausible interpretation, that doesn't help them. But it is not, in fact, a plausible interpretation.
But counsel, and I know Mr. Weigel cited in your brief, you cite all these cases that interpret offer to vote differently than the Pennsylvania Supreme Court has interpreted it. Aren't there also decisions from other courts interpreting method of voting in other states to mean machines something other than an actual paper ballot, and that haven't interpreted it to mean a mail-in ballot.
So we didn't cite any of the, I don't believe we made much of the other states' decisions in our briefing, and I haven't paid a great deal of attention to them because, what one constitutional provision means in one state may not, isn't dictated by what other courts. The vast preponderance of courts have said, that offer to vote isn't limited to in-person voting, and methods is not necessarily limited to voting machines. Now, the Commonwealth Court in this case said in the majority opinion that the amendment to the other methods of voting prescribed by law referred to voting machines, and we know that from Chase versus Lancaster. That is, I'm sorry, city of Lancaster City. We know that's not true. In Lancaster City, what the court said was the secrecy requirement was put in because there was, at the time, some experimenting with voting machines. And we want to ensure that whatever, quote, method of voting the legislature authorizes will, in fact, maintain the secrecy of the ballot, which, of course, was not necessarily true in the early days of this state, where you would just show up with a list of the people that you wanted to vote in the presence of, lobbyists for each party yelling and screaming at you if you were holding the wrong list.
May I ask you two questions before your time draws nigh? And I ask the first one because I really can't remember. In your research, are the section heads of the Constitution part of the Constitution, rather than just in statutes that are informatory?
Yes, they are. I believe that they were added. There were no section heads in the 1838 Constitution, but I believe this court has stated, and in any event, I believe it's true that they were added in subsequent constitutions adopted, whether that occurred in 1901 or.
So you would.
It is part of the Constitution, yes.
So they have substance. So when you look at Section 7, Article 1, it says qualifications, you say, well, that's who should vote. And when
Right.
you look at Section 7, Article 4, it says method of election, that's how do you vote?
Right, that's entirely right. And the reason that Section 1 was added in 1838 was, and the legislative history makes this very clear, was that people were voting, often multiple times in different districts in the Commonwealth. There was no requirement there was no constitutional requirement that you vote only in the district in which you resided. And that's what the purpose of Section 1 was. You are not qualified to vote in any district other than the district of your residence in which you've paid taxes.
May I ask
Now-
you finally, just get my last question in before you're done. If memory serves me, Article 1, Section 4 of the federal Constitution, which is getting current and very much in vogue on the unified legislative theory, it is the time, place, or manner clause, and says that's remanded absent a subsequent act of Congress to the legislature.
Correct.
Does the legislature speak through the Constitution? So to the extent that the legislature passes something, the governor need not sign it in Pennsylvania for it to be a constitutional amendment. The people must adopt it. And they greatly limit or greatly expand methodology. Is that the legislative pronouncement?
It certainly is.
And it would
in fact,
bind the legislature subsequent to that, absent a repeal of that constitutional amendment?
Absolutely, and that was the holding of the U.S. Supreme Court, actually in a case that I argued, the Arizona legislature versus the Arizona Independent Redistricting Authority, where the legislature was saying, excuse me, the Constitution says the legislature, and we are the legislature, and we don't authorize this.
Are you going to finish for me, and then Justice
yeah.
Todd has a question, and then I think we're done.
So I just want to touch very briefly on the the issue of the reliance interest, which is insofar as you feel that you need to overrule either Chase or Lancaster City in order to reverse, you need to take into account. And here, the reliance interests, I respectfully submit, are entirely one-sided. There are millions of Pennsylvanians, almost 5 million at this point, who have voted by mail under Act 77 and Act 12. There are, for over 50 years, there are millions more Pennsildanians who have voted absentee under pure legislative authority that the appellees insist, under the logic of their reasoning, was unconstitutional. And so, Justice Brobson, your point that those post-1968, the 4 legislative expansions of absentee or mail-in voting are not before you per se. The logic of the Commonwealth Court's decision and the logic of the argument of every single one of my friends on the other side is that if this can't be done by legislation, all of those acts of the legislature, which with one exception have never been challenged, and as to which there is long acquiescence and reliance interest, those also are illegal and will be henceforth illegal. If the law is invalidated in this case, there is going to be, at a minimum, massive confusion. There are 1.5 million Pennsylvanians that have already registered on the permanent mail-in ballot list and who are expecting to vote by mail 2 months hence in the primary and later this year. They don't think they have to do anything else. They know, because they are on the list, that a ballot is going to be sent to them in May and in November. And I submit that that affirmance of the Commonwealth Court's decision is going to necessitate massive disenfranchisement of voters who've come to rely on the current system and believe that they are going to be able to vote by mail. And by contrast, there are no cognizable reliance interests on the other side. There's no cognizable reliance interest in imposing a system of democratic elections that allows fewer rather than more people to participate in who will be selecting them. And so far as I can ascertain from the briefs of my friends on the other side, their reliance interest is, we would rather not run for election in the upcoming elections, in an election that allows people who vote by mail, who we believe may not, on balance, tend to favor us. That's not a cognizable interest in our constitutional system. You know, I was asked, I don't think it's been argued by the other side, but I was asked at the moot court that I did before this argument, well, isn't there some reliance interest in the fact that, you know, prior to 1977, there were categories of absentee voters that were added by Constitution, and maybe there's a reliance interest in the belief that a constitutional amendment is required. The answer is no, and in any event, any such reliance interest has been dispelled in the last 50 years because there 4 times the legislature has...
Mr. Waxman, courts are always loath to upset the forthcoming election. And we had nothing to do, obviously, with the timing of this case,
Right.
which arrives on the doorstep of the primary. But if the stay remains in place until May 18th, doesn't that give ample time to straighten things out prior to a general election?
I mean, I don't think so. There are millions and millions of people who would need to be re-educated, millions and millions of dollars that the state will have to spend in re-educating them. But look, just so that it's entirely clear, my submission is neither Chase nor Lancaster has to be overruled.
Please wrap up for us.
Yeah. I said that I would address the federal constitutional claims, and I'm confident I can do that as briefly as we did it in our brief. There is honestly, there is no serious argument that this violates the federal Constitution. All but 1 or 2 of the theories of my friends on the other side depend as a predicate that you find that Act 77 violates the Pennsylvania Constitution. And even if it does, I know of no case standing for the proposition that something that violates a state constitution per force violates the federal constitution. I mean, there is no such case. The courts have held repeatedly that you don't have a 1938 action based on the violation of a state constitutional provision. They also raise an issue of vote dilution under the Equal Protection Clause, citing Reynolds versus Sims. That was a malapportionment case. That's what voter dilution refers to. The whole notion that my vote is diluted because I don't want other people to be allowed to vote is, well, enough said. Thank you.
Thank you very much. Mr. Dimio, did I pronounce that correctly?
Close, Mr. Chief Justice. Domino.
Dimino, I'm sorry.
Quite all right. Thank you. Mr. Chief Justice, and may it please the Court, my name is Michael Domino, and along with Walter Zimmelong, we represent Mr. McLinko. I will address Act 77's incompatibility with Section 1 of Article 7 of the Constitution. Arguing co-counsel will address the particulars of the legislative challengers, and Mr. King will address remaining matters at the end. For 160 years, this court has interpreted the Pennsylvania Constitution to require in-person voting, subject to the specific exemptions noted in Section 14 of Article 7. Act 77 violated this requirement by extending mail-in voting to every voter in the Commonwealth. Act 77 is therefore unconstitutional, and the judgment of the Commonwealth Court should be affirmed. The issue at the heart of this case has already been decided twice by this court. The phrase "offer to vote" entered our Constitution in 1838 and was authoritatively interpreted by this court in 1862 in Chase versus Miller. This court could not have been clearer about the precise issue that is before this court today. Quote, "The ballot cannot be sent by mail," unquote. That interpretation was reaffirmed in 1924 in Lancaster City. The constitutional phrase "offer to vote" has never been amended.
In your view, sir, actual holding or dicta?
Absolutely an actual holding, Your Honor. There is no other provision of the Constitution that the appellants refer to that could have been the basis for the Chase court's holding. The only potential reason that Chase relied on, and certainly I think the reason that it did rely on, was offer to vote. That is what it said. Now, what the other side says is that there's some reason why we may have required in-person voting, that the people may have been particularly concerned about potential problems with respect to secrecy or whatever else. And that may have been a reason to require in-person voting.
It seemed to me that the cases, and I acknowledge the language, and it's tricky, but the cases were factually distinguishable. In the Chase case, just to take the origin case for the language, the military commander could establish the voting district. We don't know what the military commander would do, how he would do it. We didn't know if they, as your other side said, whether Pennsylvanians would vote or others would vote, whether Erie would vote in a Philadelphia election or vice versa. And so we said, no, only Pennsylvania can set up and administer the voting districts, and the military cannot do that. And then everything else seems to be surplus language. But you're saying that the rest of it is the actual holding of the case.
Yes, Your Honor. I think that the holding of the case was offer to vote. There's nothing in the case that says that our decision would be different if somebody had thought of the idea of using a secrecy envelope, or if some other kind of procedure had been used. The constitutional language that Chase pinned its holding on was offer to vote, not who may administer the election when someone comes and offers to vote or anything like that. It was the voter hasn't offered to vote if he hasn't.
I respect you have a position you can argue. So my last question on the topic, because again, it's a topic that I looked at hard and thought about hard. If instead the legislature had set up what we today know as absentee voting for the military, for the sick and disabled or the like, same result in your view?
Yes, Your Honor, I don't think that that's any different from the actual case. I think that in Chase versus Miller, the legislature did set up exactly what you'd call a system for absentee balloting for soldiers who were volunteering for the Union cause, and what this court said is that's not consistent with the Constitution.
Fair enough.
And to the extent,
Counsel, does it make a difference that the Chase court was focused on the fact that suffrage was designed at that point in time to essentially exclude 3/4 of the population? And so they were looking at this provision through the eyes of a very restrictive suffrage limited to white men of a certain age, and they wanted to make sure that the white men of a certain age who showed up at the polls were the correct white men of a certain age. Was that the driving force behind their decision, or at least one of them?
Your Honor, the court mentions that the 1838 Constitution did restrict voting.
Well, you do more than mention it. They say it was not questioning the intelligence of other citizens to vote. It is designed essentially so that the people that have deemed to be worthy of voting are only those people who can vote.
Yes.
I mean, that's what the case says.
Yes,
I mean,
yes.
What part of that rationale is worthy of continued adherence by this court in terms of interpreting the Constitution?
The answer, Your Honor, is that the people have changed the parts of the Constitution that have dealt with those portions of the Chase versus Miller's restrictive understanding of the voting right. That whatever might have been the basis in policy for the people's decision to implement that in the 1838 Constitution, or Chase's decision to interpret it that way, whatever the policy basis was, the fact remains that the Chase court did interpret offer to vote to contain an in-person voting requirement. The people thought that restricting the franchise to white male property owners was bad policy, and so they amended the Constitution to get rid of that. But they didn't amend the Constitution to get rid of the in-person voting requirement.
Let me just follow through on that, because as you could tell, I think we've all spent a lot of time on this interesting case and the case law. So we're sitting here interpreting the 1968 Pennsylvania Constitution. Am I correct? There haven't been any amendments since then that we're concerned with.
That's
that
correct.
Accurate? Okay.
There's the 1985 amendment to Section 14, but I agree with you that's not
More or
central
less,
here. Right.
More or less. And so since Chase, the Constitution has been amended to require registration protocols to be set up. In 1901, it was amended to include the language allowing the General Assembly to allow or to decide the manner of voting. And so as we look on a continuum, don't we have to view the language offer to vote in the context of that continuum? Now there are other things that have been added to the Constitution, either by a convention or constitutional amendment. And so if we look at that as a whole, if we look at the Constitution holistically, aren't we left with the proposition that we have a provision in Section 4 that allows the General Assembly broad, almost plenary authority to determine the manner of voting? And if we put all of that together in the context of what we see in our 1968 Constitution, where is it that the Constitution explicitly precludes the General Assembly from allowing the provisions of Act 77 to go into law? Where is that explicit exclusion of the General Assembly's ability to allow voting by mail?
This court held in Chase and reaffirmed in Lancaster City that the phrase offer to vote was an explicit requirement of in-person voting. The court's
What about the grant to the General Assembly, a broad grant to the General Assembly, to dictate the manner in which the the vote will be allowed? What about that language?
Very respectfully, Your Honor, that's not what Section 4 says. I understand that the appellants have asked this court to read plenary authority into Section 4, but that's not what it says. It does not say that the General Assembly may prescribe methods of voting. What it says is that it requires that elections be, quote, by ballot or by such other method as prescribed by law. It's not written as a grant of power at all.
What does that mean then, as prescribed by law?
As may be
prescribed by law. That's the General Assembly who prescribes by law.
I'm sorry, I didn't hear.
I'm sorry, I shouldn't have chimed in.
I think-
just said, what else could it mean?
Yeah.
No, what it means is, if we apply the nos catura sociis canon and interpret ambiguous phrases by reference to their companions, we figure out what method means by reference to the other more specific terms in the same phrase, most particularly ballot. It is by ballot or by such other method. The idea is that method includes some other way of recording votes, some other mechanism for voters to indicate what their choice is. So that provision authorizes the legislature to say, if you want to vote by punch cards, you can vote by punch cards. If you want to use optical scanners, you can use that. If you want to vote by mail, maybe you can do that, although that would undermine the secrecy provision. If you want to use touchscreen voting, that's fine. Those are methods of voting, or
I'm lost, though, and I want to interrupt you just because you're at the heart, I think, of what you've been asked. You just said, under Article 7, Section 4, so long as you maintain secrecy, you can vote by mail.
No, Your Honor, that's not.
And I misheard you, so go ahead.
No, I'm saying that the method of voting that may be prescribed by the legislature is the mechanism that allows voters to indicate what their choice is. It is not plenary authority to impose whatever kind of election procedures the legislature thinks is appropriate.
I thought you just said that voting by mail was one of those possible methods. Maybe I misheard you.
No. I said by voice. Maybe I misspoke. I meant to mean viva voce voting.
Justice Doherty? I'm sorry, Justice Donohue.
Let me just probe that with you for a moment, because and I'm going to take your argument. I mean, you say Chase means a ballot presented in person.
Yes, Your Honor.
Okay. Well, Section 4 allows for a ballot to be presented otherwise, if there are other manners that are permissible. And that's why, as I read Section 4, I do see that as a broad grant to the General Assembly to determine another manner of presenting a ballot. If you're working from the proposition that ballot means present in person, present a ballot in person, I read Section 4 to say, or present a ballot in another manner.
I respectfully disagree with that.
Without losing Justice Donohue's question, If you read it differently, you violate Article 1, Section 4 of the federal Constitution. So with that, answer the question.
I respectfully disagree with with Justice Donahue's interpretation of Section 4. I think that that Section 4 should be read to be consistent with Section 1, and in particular with this court's interpretation of Section 1, that the Section 1 establishes who may vote and where they may vote. Section 4 says, once you get to the polling place, here's how you record your vote. I think they deal with entirely different topics.
See, that's why I'm groping with it, because, you either take Chase on its face or you don't, because Chase says that the ballot has to be presented in person. Okay, and so I'm taking that to mean a ballot is presented in person. I then look at Section 4, and it says that the General Assembly can determine another manner in which a vote can be, a ballot can be presented.
I don't think that
Chase says what it says, but Section 4 says what it says, and I cannot read Article 4 to expressly prohibit a ballot by mail. And that's essentially the position that we're put in, given our, constitutional interpretation jurisprudence.
Well, our claim is not that Section 4 explicitly precludes it, it's that Section 1
But you have
does.
to read them together.
Well, yes, Your Honor, that's exactly my point, is that we shouldn't read Section 4 to abrogate this court's decision about Section 1, that there's nothing that, as I read it, in Section 4 that says anything about allowing methods of voting that are other than in person. The only exceptions to that are in Section 14. And I do want to make another point about why this appellant's broad reading of the so-called plenary power that is supposedly in Section 4 doesn't exist. Compare the language that appellants are focusing on, that one word that they cherry pick out of context, this method in Section 4. Compare that to the opening language of Section 6, which says, Section 4 says, by ballot or by such other method, and they think that includes all manner of election procedures. Section 6 says, quote, all laws regulating the holding of elections, unquote, shall be uniform across the Commonwealth. Well, if Section 4 really was meant to include a plenary power to pass all manner of election procedures, there was a model for how to convey that authority 2 sections over. It could have used identical phrasing, and it didn't. It is simply implausible to read by ballot or other method to include authority for passing whatever kind of election procedures the legislature wants.
May I ask you, sir,
Of course.
I just want to make sure I understand your argument. Is your argument that the legislature doesn't have the power to do mail-in balloting? Or is it that the Constitution is now written doesn't express the legislative will to allow for mail-in balloting?
I'm not sure I appreciate a distinction between the two
If the
forms of the
legislature
question.
comes out next week and passes a constitutional amendment and the people pass it, we want mail-in balloting, and we're not kidding. Do they have the authority to do that?
Absolutely. If there's a constitutional amendment, that's what this court in Lancaster City said should happen. It's what the people of this Commonwealth have done several times when they have wanted to expand mail-in voting beyond what Chase and Lancaster City permitted. They wrote explicit exceptions into the Constitution and said, if you can't get to the polls, but you're in these categories, you can vote anyway. That's what the legislature has done in Act 77.
May I ask you your view, and that's consistent with my view. I thought you were arguing differently, so thank you. Your view of the headings of these sections, because they were informative to me, with Article 7, Section 1 saying qualifications of voters, and paragraph 3 of Section 1 saying if you've resided in the election district for 60 days, you can vote there. Doesn't say how you can vote there, and I understand that's one of the arguments before the court. but that's a who can vote, who's qualified to vote. And then Article 7, Section 4, method of voting, is tell you the mechanisms by which the people who are qualified under Article Section 1 would vote. Is that the way you see this? Or you see it that Article 1, Section 1, 3, not only is a qualification clause, but also a manner of voting clause?
Well, as I indicated, I believe that Section 1 not only establishes who may vote, but where. Now, the section headings that Your Honor references are the section headings of the current Constitution, but they were not the section headings when the offer to vote language became part of the Constitution in 1838, and they were not section headings when this court decided when this court decided Chase in 1862. I believe the heading at the time in the
Is that for you or against you?
I think it's for me. Of course, I wouldn't have mentioned it otherwise. I believe the heading at the time in 1838 was election franchise or something to that effect, which is a much broader term than qualifications of electors. In any event, once this court has interpreted the phrase in 1862, the natural presumption, the presumption that courts throughout the country have followed, is that if you want to change the established meaning of a legal term of art, you amend the term of art or otherwise do so explicitly. The argument on the other side depends on repeals by implication, repeals by this ambiguous language in Section 4, repeals from implication by going from may to shall in Section 14 and whatnot. Had the people wanted to get rid of this court's 160-year-old now precedent, the people could have done so by amending the provision of the Constitution that this court interpreted.
Professor, can I ask you, when we interpret what, if anything, Chase and Lancaster City mean today, is it important for us to take into account that neither of them were called to pass upon a mail statute, a mail ballot statute? In other words, that Chase was dealing with the military camps issue, and then Lancaster City was dealing with a military absentee voting amendment that had been passed. I wonder, as we interpret what those cases said against the language of our Constitution, is it important for us to take into account they weren't called to pass upon a situation like we have here with this mail statute?
No, Your Honor, I don't believe so. I think that in the first place, the ballots had to be transmitted from those military camps to Pennsylvania by some kind of courier anyway. Whether the U.S. mail is used or Federal Express or any other kind of courier, I don't think makes any kind of difference. And secondly, the court in Chase did not say the ballot cannot be sent by military courier. The quote was, the ballot cannot be sent by mail. And so even if that case did not specifically involve transportation by the post office, the court understood its holding to include transportation by the post office.
Counsel, I have a question. We're all aware that we should look at the intent of the drafters. So let's go back to the 1938 convention.
1838, I imagine.
1838, I apologize. My understanding is that there was lively debate regarding the qualifications of a voter, and they were trying to be very consistent with the 76 Constitution of having those who are from a community interested in voting for their community. The exact language I had commented was that all free men having a sufficient evident common interest with an attachment to the community have a right to elect officers or to be elected into offices. And that is from the 76 Constitution, and their argument regarding suffrage and elector qualification was the focus of this requirement. Now, offer to vote, my understanding, was never even entered into the 38 convention until, interestingly, Delegate Woodward, later to be the Justice Woodward, gave an impassioned speech on January 19, 1938, demanding that only white men have the right to vote, and that subsequent to the passing of the racial discrimination, is it then entered after another passion that, in essence, I believe, so that we get an understanding what he meant, the language offered to vote came in after he said, white men will not consent to the self-debasement with political and social equality which they would then imply. He said, let us rescue our institution. And he also indicated, no, sir, they are a caste with whom we never can and have the kind of intercourse which can alone qualify them to vote. That being said, share with me, with understanding the intent of the people who wrote this Constitution, where you get the position that offer to vote equals in-person election when it was all discussing the qualifications and the exclusion of African Americans from voting. That's what the intent was. So, and your paper tells us to look at years of precedent as well as the intent and meaning of the people who drafted this language. So I'm having a conflict with your position. Enlighten me, please.
Thank you, Your Honor. As this court has said numerous times, the language of a provision is the best evidence of the intent of that provision. Certainly, Justice Woodward, having been in the convention, would have understood what offer to vote means and would have understood it better than us now looking at it at 180 years.
That's what I'm sharing with you. That from looking at the intent of the delegate Woodward, he just wanted to make sure that voting was to free white men. So that's where I'm struggling with how, in his desire and statements that are recorded, that he only wanted the vote to be white men. He never said you have to vote in person.
The restriction of the franchise to white male taxpayers was accomplished by other constitutional language than the phrase that was interpreted in Chase versus Miller. We didn't need offer to vote to restrict the franchise to white men. The Constitution said explicitly at a time, of course, prior to the end of the Civil War, prior to the passage of the 13th, 14th, and 15th Amendments, prior to the amendments of this Commonwealth's Constitution that removed those kinds of restrictions. But they were built into the Constitution in explicit language. We didn't need offer to vote to accomplish the same kind of objectives.
But counsel, the best way to be certain that no one but a free white man votes is make the voters show up at the voting place. No black person is going to sneak in, or might I add woman, is going to sneak in if you have to show up at the polls and present your ballot. And I think that's Justice Dougherty's point. I mean, if there is any policy reason for showing up to vote, it's to effectuate the intent to make certain that only the right people got to vote.
I think that it's entirely appropriate that the people of the Commonwealth take steps to ensure that only the people who are qualified to vote actually cast a vote. And yes, appearing in person is one way of ensuring that. Now, at the time, the restrictions were make sure that you're a white male property owner. Nowadays, those qualifications are gone, but we still have qualifications. Article 1 establishes qualifications. It doesn't say we're going to try to maximize the number of people who are voting. It says that the following people are eligible to vote and others aren't. Having a presumption, subject to exceptions in Section 14, having a presumption that voting in person is required continues to be some amount of guarantee that the people who do cast a vote are qualified to do so. And the fact that
Finish your sentence, I'm sorry.
the fact that we now have different qualifications and that we have abandoned the racist qualifications that were in the Constitution of 1838 doesn't change the fact that offer to vote still accomplishes an objective.
Counsel, do you know the approximate percentage or the number of absentee voters who regularly vote in elections not counting mail-in, not considering mail-in, but people who are qualified as absentee voters, either by illness or being out of town for work or vacation or whatever.
I'm sorry, Your Honor, I don't know the number. I know that it's
It's
far,
substantial.
yes, but far fewer than Act 77 allows to vote by mail without excuse. Yeah.
Sure, but it's not insubstantial.
No,
And are you then implying that those voters are somehow of questionable qualification?
no, Your Honor, I'm not. I'm saying that what the people have done in Section 1 and the entirety of Article 7 is to balance different kinds of considerations. We have an interest in making sure that elections operate fairly and that people who are entitled to vote should be able to cast their vote without undue hindrance. We also have an interest in making sure that people who are not eligible don't cast votes. Now, what the people have done is to say, we're going to balance those and we're going to accept some risk that people who fill out absentee votes will be subject to intimidation by family members or others. We would like to get rid of all of those kinds of concerns. We can't, but on balance, we think that the costs of preventing those people from voting are too high. But that's a different story from saying that we should abandon in-person voting entirely just because we were willing to make some concessions to people who were unavoidably absent from the
No one
polling
has
booth.
suggested abandoning in-person voting entirely.
No, I mean abandoning the requirement of in-person voting entirely.
I think we understand your argument. You made it very well. Do you have anything you'd like to say in conclusion?
Your Honor, I'd like to, there is one item that I didn't get to with respect to Section 14 and the change from may to shall, that appellants place a lot of stress on the change from may to shall and argue that because the current Constitution says shall, that the expressio unius argument doesn't work anymore. I think it still does work, but it unquestionably works, and the appellants don't even dispute, it unquestionably works prior to 1967. Prior to 1967, when Section 14 allowed but did not require the provision for absentee voting for the specifically identified classes of voters, Section 14 would have been completely superfluous under appellants' reading of Sections 1 and 4. I repeat that if Section 4's method of voting provision gave the legislature plenary authority to create opportunities for mail-in voting for any class of people that the legislature wanted, Section 14 until 1967 accomplished absolutely nothing. Therefore, that interpretation of Section 4, the interpretation of Section 1, cannot be correct.
Counsel, let's look at that argument. Section 14 specifically indicates they're absent from their election district. That's the epitome of Section 14. Section 4 provides other methods as provided by the General Assembly. We've indicated the concept behind methods was to protect secrecy and make sure that we have qualifications. I'm not following your argument because mail-in, Act 77 is no excuse voting as opposed to absent from the election district. It is comparing apples to oranges. How can you say that no excuse voting equals absentee balloting?
What I'm saying, Your Honor, is imagine that we have to figure out what authority the legislature has under Section 4, this provision that authorizes the legislature to prescribe by ballot or by other method of voting. What I'm saying is that if that authority included the ability to allow all voters of the Commonwealth to vote by mail, which is what the argument is, then there would have been no reason for the people to say in Section 14, you know, the legislature, if it wants, it can offer these classes of people the opportunity to vote by mail. That's the argument that
I'm not sure I understand it either, because it's not self-executing. It said legislature, you can do that. Perhaps it was just an expression that we would like you to do it, and in 68, rather than saying we would like you to do it, we said you must do it. But the legislature still has to describe how to do it, and that's the methodology.
But appellants are arguing that they had that authority anyway.
I think they probably did. They did, and they still do. right.
Can I follow up, Professor? Are there instances in either our federal or state constitution where such arguable surplusage exists?
There are, there is the reason that there is a canon against surplusage is because that kind of reading is disfavored. There are, of course, certain instances, particularly in statutes, where the legislature will adopt what the appellants use as a metaphor, the belt and suspenders kind of rule, that will write language that in case what we said here doesn't quite cover everything, we're going to use similar phrasing. But it is rare to the point of no examples come to mind when a second provision would be completely unnecessary and completely subsumed by a broader interpretation of a different and earlier provision.
All right, thank you very much, Counsel.
Thank you, Mr. Chief
Well
Justice.
argued.
Any other questions? No. Good. Mr. Tufel.
Thank you, Mr. Chief Justice. I am Greg Tufel. May it please the court. I have the privilege today of representing the petitioners, the House of Representatives members, who are appellants and cross-appellants as well, Timothy Bonner and 13 other members of the Pennsylvania House of Representatives. Now, there's a basic theme I'm going to come back to and start with, which is that this case is about 9 million registered Pennsylvania voters being disenfranchised and denied the right to vote on whether to amend the Pennsylvania Constitution to allow no excuse mail-in voting. This is an epic.
Why was it such a good idea when the legislature passed it, and now it's alleged to be unconstitutional? What happened in the meantime?
Well, thank you, Your Honor. One clarification. 2 of my clients weren't in the legislature when Act 77 passed, and one of them voted against it, but be that as it may, my point here about the people of the Pennsylvania, the voters, the 9 million voters, they have a role in amending the Constitution, and it is not up to the legislature to contradict the will of the people expressed in the Constitution. They had a role, not just the legislature, in drafting the Constitution and in accepting the amendments of the Constitution as it was amended. So this is not up to the legislature to decide that Act 77 is constitutional flying in the face of the language of the Constitution as dictated by the people and the legislature.
Sure, and we understand
Yeah.
that. My question was, when the Pennsylvania legislature enacted this act, they must have believed it was constitutional, and we would find it presumptively constitutional unless proved otherwise. What happened between then and now for your clients?
Yeah,
The ones that were in
the 11, right, the 11 that were in the legislature prove that that argument's false. They wouldn't be here contesting this, sorry, go ahead.
My question was, what happened between then and now to make it now alleged to be unconstitutional?
They became aware of the constitutional infirmity of Act 77. They were ignorant of it at the time they signed it into law. And that gives the lie to the argument that because 70% of the legislature voted in favor of it, they must agree with all of the respondents' arguments. They weren't aware, Your Honor.
It wasn't that so many people voted by mail-in ballot. That wasn't what changed their mind.
No, Your Honor, it isn't. It's due to the constitutional infirmity that they later realized. And they regret not realizing at the time. And they now view it as their duty to bring before this court the constitutional issue to correct their mistake in enacting an unconstitutional law.
Mr. Tufel, is the
Yeah.
constitutional infirmity that they recognized exactly what Mr. Domino just argued?
I would have some clarifications to what Professor Domino argued, if the court would permit me.
Professor, I'm sorry.
So, no, but I don't think he got to fully express all the basics. But
Although,
the limitation on the
Very respectfully,
He would-
you don't get.
I won't.
You don't get to do rebuttal
I will not.
because he didn't get to say it.
No, you're right, Your Honor. I have additional
did argue
points.
for close
Yeah, I
to
have
an
different
hour.
additional points that I would express. Our argument that the legislature is constrained is based on Chase and Lancaster and on Section 1 as the limitation on the qualifications of voters. And the qualifications on voters include that you in person offer to vote. That is part of the definition of the qualification of voters, that they have that action of presenting in person.
I'm going to give you some opportunity.
Yeah.
But very respectfully, that's the precise argument we just spent an hour on.
Yes, Your Honor. So, Your Honor,
It's unfair to your friends on the other side and frankly to us to listen to it again. And,
Sure.
and frankly, we understand it. We asked a lot of questions and we've studied it hard.
Let me explain, Your Honor, if I may, that the other side, for the first time at oral argument, you'll notice it wasn't in the brief, and Your Honor brought up the word dicta. They accused Chase's holding that offer to vote means in-person voting was mere dicta. That in fact, the basis for Chase was that they were trying to have votes in a military encampment outside of Pennsylvania, and that's really the holding. And it's just dicta, offer to vote. But if you actually read Chase through, they discuss offer to vote and the meaning of offer to vote completely divorced from discussion of military encampment. It's only after they explain the meaning of offer to vote, and they look, Your Honor, to the legislative history, not legislative history that Justice Dougherty pointed out of perhaps certain legislators wanting people to show up in person to confirm that they're white, but rather the legislative history. There was a Philadelphia registry law that the offer to vote provision was based upon. And that Philadelphia registry law is referenced, if Your Honor would like the page number of, it is, I believe it's page 35 to 37 of Chase v. Miller. And, oh, sorry, those are the Lexis pages. 418 to 419. Yeah, it talks about how the latter amendment was probably suggested by the registry law, which was passed in 1836 for City and County of Philadelphia, the main object of which was to identify the legal voter before the election came on and to compel him to offer his vote in the appropriate ward or township, and thereby to exclude disqualified pretenders and fraudulent voters of all sorts. So, if it was in the mind of the judges to also exclude voters who weren't white, well, it was only because that was one of the qualifications at the time, and not because that was. So, I think the Justice Dougherty's reference to legislative history.
Dougherty.
Sorry, Dougherty. Oh my gosh,
Justice
I
Dougherty,
apologize.
sensitive to that.
I apologize, Justice Dougherty. When it only feeds into the notion that they introduced offer to vote specifically to require in-person voting. That was the correct interpretation of what they meant at the time, of what the founders meant by introducing. They wanted in-person voting in order to help verify all the qualifications and that the voter wasn't fraudulently representing themselves to be someone who they weren't.
Counsel,
yeah.
I think what you just said is key. They wanted to verify the qualifications. Not that it was a qualification to appear in person. It was there to verify the qualifications. Correct?
But it is included in the qualifications that one present oneself and offer to vote before one's allowed to vote.
So it's both.
Offering to vote is part of the qualifications. It's included in the section on qualifications because it is a qualification.
So it's not there to verify qualifications, your understanding.
It's there, its function helps to verify that the other qualifications are met, but it is in itself also a qualification that one present oneself and offer to vote in person at the appropriate election district. And that's how Chase read, the original Chase decision read it, and how Lancaster City affirmed it. And you will find the other Chase decision that we cite to be a treasure trove of legal reasoning that really answers nearly all the arguments that are presented by the respondents in this case, and that's the Chase versus Lujan, the New Mexico Supreme Court case. And it talks about this idea of dicta that the Chief Justice brought up. And it says specifically that The argument is faulty and fails to impress us as sound that while it is true that we might have decided Thompson v. Shire without determining this point, the question was presented as argued as one of the grounds of unconstitutionality inhering in the absentee voter law. The fact that a court of competent jurisdiction may declare a statute unconstitutional on 2 grounds, where it might have rested its decision on only 1 ground, does not make the decision on the 2nd ground dictum. Now, what the court in Chase did is they explained offer to vote means in person. It's a qualification for voting, and it is a requirement to vote, and that's why you can't courier, however they were getting the votes from the military camp to the election district. They need to present it in person. And then they went on to say, well, wait, what if, and the law didn't actually do this, but what if the law gave the power to the military commander to establish an election district at the military camp? And they said, well, they can't do that because that would be outside of Pennsylvania. And so you can't say that the military person is offering to vote in person at the military camp because the military camp can't be an election district. That is a separate second additional sort of pontification after they've already established the point, independent of any of that discussion, that offer to vote requires in-person voting. The court did not hold in Chase that, oh, go ahead.
Sir, if the legislature wants next year, I said to someone else, to enable mail-in, no-excuse voting, is the only way they can do that to take the words offer to vote out of Article 1, or Section 1, Paragraph 3?
Or they could just do a separate amendment that says, in fact, there was an amendment proposed to that effect at one point that would have eliminated in-person requirement. And they could put it elsewhere in the Constitution, but they would need to expressly state their intention to contradict the well-understood meaning of the offer to vote language in Section 1, which is established for 160 years the qualifications of voters in Pennsylvania.
So if they put it somewhere else in the Constitution, that eliminates the construction of offer to vote
Right.
that we now have.
They could put it in a different section, but they'd have to clearly explain in the amendment, we want to enable mail-in voting and eliminate the requirement of in-person presentment. And they actually have proposed such amendments, Your Honor.
Eliminate the requirement of shall offer to vote, to offer to vote requiring that being in person.
Right, right.
They'd have
But
to
if I may follow up on the
Yeah.
Chief Justice's question, thinking about your answer in conjunction with Professor Domino's argument on the point, wouldn't your position be that removal of the offer, or amendment of the words offer to vote would in and of itself not suffice, right? You would require, you feel that you feel that voting by mail, no excuse voting by mail would require specific authorization for that.
No, I'm sorry. Whoa, I moved my microphone, and wow, did that make a difference? If you remove the language offer to vote, you cut the legs out of any limitation on the legislature that exists presently in the Constitution.
Okay,
I agree.
So in other words, the surplusage argument that Professor Domino was making toward the end would not, in your view, require more than mere removal of the offer to vote language.
I'm not sure I fully understand the question, Your Honor.
Okay, so as I took it, Professor Domino was arguing toward the end that the appellant's argument would render Section 14 mere surplusage, and certainly up until 1967. But I'm hearing from you that the statute in question here would not be unconstitutional were the mere words offer to vote removed.
Right. If the Constitution were amended, if Section 1 of Article 7 were amended to remove the terms offer to vote as one of the qualifications of voter, that would no longer be a restriction on the qualifications of voters, and they could present by various methods vote, whether it be via vote J, whether it be via a punch card, whether it be via a ballot, as Act 77 does, which is by a ballot.
Therefore,
Yeah.
given that that's your position, Mr. Tufel, doesn't that cut the legs out from under the argument that Section 14 is mere surplusage? You know, the expressio unius argument in that regard.
Well, the point of the expressio unis argument, at least as we've presented it, is that the amendments in 1949, in 1953, in 1957, that had may language on absentee voting provisions, were completely pointless. How clueless we were when we amended the Constitution, that all the way back in 1901, the Constitution was already amended to explode the in-person voting requirement and enable the legislature to allow people to vote without offering to vote in person. And that wasn't the understanding in 1949, in 1953, in 1957. And when they made the exception mandatory, the exception to in-person voting that absentee voting allowed, when they made it mandatory, they still weren't exploding the concept that the usual rule and the requirement for otherwise qualifying to vote under the Constitution is presenting in person, offering to vote in person. Section 14 didn't completely abrogate that requirement. It created a number of exceptions to that requirement. And those were necessary exceptions if you wanted to allow anyone to vote otherwise than offering to vote in person.
Well, it created exceptions first.
Correct.
And then unless we get into the grand may versus shall debate, which I'm a big admirer of Justice Weck's opinion on may versus shall, let's assume the change was intentional, and that for some reason the legislature was not affecting the will of the people in the sense of enacting absentee ballot measures for those classified under the may. That was the idea. It converted that to an absolute right to cast an absentee ballot. And that's about as far as we should read it.
Correct.
Counsel, am I correct that it is a question of first impression as to the interpretation of the language in Section 4 that deals with methods of elections?
No, Your Honor. Lancaster City specifically addressed those issues. And although Your Honor is correct, there is an extensive analysis, you'll note that in Lancaster City, this court cited the Jenkins case out of North Carolina, which contained all the arguments being presented by the respondents, and expressly, I'll give you the page if you like, to where it's referenced. It's referenced on page 135, Your Honor. It rejects courts from other states, including the Jenkins case. And the Jenkins case says offer to vote doesn't have to be in person. Gosh, it could be mailed. It could be, it could be anything.
Tell me your pinpoint citation again, because
page 135, Your Honor, of the, and let me just make sure I'm not misleading you. Yeah, that's correct. Page 135, it says the same view was taken in many other states during the Civil War period where like constitutional requirements existed. And it goes down to cite a number of decisions, including at the bottom of that paragraph, Jenkins versus State Board of Elections.
Are you referring to Lancaster City?
Yes, Your Honor. Right.
And a reading of this case, Lancaster case, your reference to the citation of Jenkins is to give the opposite position of this court compared to other courts' interpretation of the language.
Correct. And my point in bringing that up, Your Honor, is this court acknowledged, not my argument, this court's argument actually, this court acknowledged that there were contrary arguments in other courts in other states, including all the arguments presented by the respondents. They are set forth as eloquently in Jenkins as they are by the respondents today. And nothing has changed since the same arguments rejected in 1920, there's no basis to suddenly embrace those arguments in Jenkins today that offer to vote doesn't have to be in person.
Counsel, can we just go back to my question? Because my question was, has this court ever interpreted Section 4? You gave me a pinpoint citation to a discussion that was concerning the predecessor Constitution, the 1838 Constitution. The reference to further it is provided by Section 4, where it cites the text, is in the context of the Constitution of 1874.
No, the 1901 version, Your Honor. This case was decided in 1924, so it would have been the 1901 version of the Constitution.
I understand that, but the reference to Section 4 is on page 136 of the decision. And then there's no discussion. It cites Section 4.
Right, but my point in bringing up Jenkins, Your Honor, is that this court was well aware of those types of arguments because they were raised in Jenkins. I'm sorry.
Justice Donovan.
Sure, I'm sorry, please,
I'm
go ahead.
asking you
Yeah.
where it is that Lancaster City discussed Section 4.
The location you just described,
But they didn't discuss it.
they
They
quoted it
quoted it.
without,
Period.
yeah, you're right, without, that's what I acknowledged at the beginning of my argument on that point was, you're right, they don't engage in detailed analysis, but they cite a case that does, and they expressly reject it.
They didn't cite it in the context of discussing Section 4. That's my point.
Yes.
And really, I think that's the point of, why I keep getting back to this section, because I think it's key to our analysis. I'm not aware of any case from this court that interprets what Section 4 means, aside from our discussion of the privacy provisions of it, which we dealt with in the 2020 election cases. So, and I'll say it this way. Aside from your view that Lancaster City interprets Section 4, are you aware of any other case from this court that interprets that section?
None beyond Lancaster City, Your Honor. However, I would note that the Chase versus Lujan case addresses also directly the same argument in following Lancaster City. But you're right, from this court, your answer is no. I am not aware of any. Yeah.
Would you finish up for me? I think you're arguing a variant of the same argument that the professor made. And again, I've forbear to give you the opportunity because you came and you prepared, but I think we should move on.
Right. A couple key points then, moving on. Registration existed at the time Chase v. Miller was decided. In fact, the offer to vote provision was drafted based on a registry law out of Philadelphia. And registration existed at the time of Lancaster City. So the argument made by the respondents that today we have registration. You don't need to be showing up in person. Registration accomplishes everything that showing up in person ever did, so it obviates the need. To the extent those policy arguments hold any sway, registration existed back then as well. Your Honor raised issues about the section headings of the provisions being important. The section headings of qualification of voters was introduced in 1874 for this particular section, and there was a section heading in 1838 for Section 1, and the 1838 version had a section, it was titled Election Franchise at that time. So just to help guide that analysis. Contrary to the respondents' contentions that Chase ignored legislative history, Chase relied on legislative history with regard to that Philadelphia registry law in determining what offer to vote meant. And in the Chase versus Lujan opinion, the New Mexico decision, it notes that the determination that offer to vote means an in-person presentation of vote was supported by a common law rule based on immemorial usage, which would give the phrase offer to vote the meaning of personal presence in connection with the offer, basically saying that it was well understood throughout the common law at the time that offer to vote meant in person. This wasn't some strange idea of Justice Woodward come up with at the spot that offer to vote meant in person. It was deliberately inserted to require in-person presentation of voting, and that's what it meant. That's very clear.
Well, I'm glad that you have rehabilitated Chief Justice Woodward, because he was rolling over in his grave hearing everyone criticize his decision.
Seemed to me he should have recused himself, but we're a little late for that.
Okay, Your Honor, so I just want to come back to the point I started with, I guess, in closing here.
Try to conclude for me.
Sure, absolutely happy to.
Thank you.
I was talking about the 9 million Pennsylvania voters. This was an epic and fundamental change to the way we vote in Pennsylvania. Whatever your view of whether it's good or bad, whether it sacrifices voter integrity, whether it subjects voters to being pressured by people to vote in nursing homes or at their home, or whether you think it's great that it allows greater accessibility to voting and makes voting more convenient, this is an epic fundamental change none of us can deny. And the Pennsylvania voters have a right, when you want to amend drastically the method of constitutional voting, to have a say in whether we amend it this way. It is not just up to the legislature to decide, we think this is a good idea. They must put it on the ballot, must give Pennsylvania voters a chance to vote on this. And that concern has to be primary for this court as well. Their right to vote on constitutional amendments needs to be respected. And that is why these petitioners asked me to bring this case on their behalf. Thank you, Your Honors.
Can I just, from
Sure, absolutely.
the client's perspective?
Yes.
What happens to all of the voters from Pennsylvania who go to Florida and South Carolina on January 1st and don't come back until
Snowbirds.
April 1?
Yeah.
Who for years have been voting by mail. I mean, your argument totally does away with that possibility. I mean, because that was by statute, long-standing statute. Lots of people have been relying on that and, you know, working from the assumption that the votes that they're casting are constitutional and they've been counted. So what happens to all of those people under your interpretation of offer to vote?
We're only asking to strike down Act 77, not other absentee voting statutes. I do think that there is some constitutional infirmity in other absentee voting statutes in that Section 14 itself contains time and place requirements that may not be followed. But I don't think necessarily that the vacation limitation in the statutes is necessarily contradicting being out of their voting district for business. Business could be interpreted to mean personal business. The statute that they're referencing that allows people on vacation to vote, like your snowbirds, it specifically interprets the phrase out of the area for business to include being out of the area on vacation. Is that a reasonable interpretation? For another day, you know, but it's not insane to say personal business is included in business. It's not crazy. Maybe it's not an argument this court would accept. I might not even agree with it, but it's not crazy.
Well,
And-
it sounds at least,
Yeah.
it sounds at least as crazy as Appellant's argument, doesn't it? I mean, I want to follow up on Justice Donahue's question.
Yeah.
If you're right, how can those statutes to which she was referring be constitutional? Because if you're right, then the presence of Section 14 in our Constitution means that any other voting other than in person is by definition unconstitutional, except as specifically provided in 14.
Correct, Your Honor. 14 is the sole exception to the in-person voting requirement.
Right. So if you prevail, that does implicate all of those other provisions, vacation, snowbirds, what have you. Isn't that right?
I mean, if they go beyond what Section 14 allows, then yeah, challenges could be brought to those using similar arguments that I present today.
Why wouldn't your clients bring that argument? I mean, why is it that they're discerning between doing away with voting by mail, as we know under Act 77, and allowing people who are snowbirds, retirees who are on vacation for 3 months in Florida? Why wouldn't they step up and say, we didn't know this was unconstitutional. Here we are now. It's our obligation to bring to the court. What, are they going to squint?
Well, I think that, I mean, the motivation to bring actions challenging constitutionality of provisions like that has to do with same concepts that guide standing. When there's sufficient harm to sufficient people that they have standing to bring an action, they are so motivated to bring an action to challenge a law. So, yeah.
You introduced your argument with the fact that you're representing the lawmakers who realize the errors of their way.
Yeah.
So, following up Justice Donahue, these statutes would also fall in line with the error of their way, which means if you're talking standing, if they don't have standing to challenge the unconstitutional statutes which they passed, then they wouldn't have standing for you to be here today. So the question is from Justice Donahue, let's be candid. What it really looks like is that maybe some legislators are concerned because the no excuse balloting at least recently, shows that maybe one party votes overwhelmingly by mail-in ballot as opposed to another. So maybe this is an attack for supremacy at the ballot. I don't know, because that's not evidence in this record. But what is or even what we're trying to follow through is your argument that they want to correct a wrong. And Justice Donahue raised a very salient point. They have standing to challenge the unconstitutionality of all their enactments. Why didn't they do that? So that we could resolve this, so that we could protect the 13.5 million people in Pennsylvania, and not only that, but those who are registered to vote.
I think there's just practical realities, Your Honor. To bring a lawsuit, you need to raise funding, you need to spend time on it. They have other priorities.
The same argument, counsel, all for the price of you.
Why aren't you
Yeah.
Taxpayer
got it.
funding, isn't it taxpayer funding we're talking about? You said they need to raise funding.
To pay lawyers like me, Your Honor, to bring...
Oh, you're not pro bono?
No, I'm not, Your Honor.
One further question.
Yes, Your Honor.
While you were here,
Yeah.
and these are so obviously patently unconstitutional, why didn't you challenge the statute that allows snowbirds to vote from Florida?
It
wouldn't have cost any more.
probably didn't think it all the way through, could have included it, but I mean, it just wasn't a priority.
FYI, I'm not sure your clients do have standing, and I am very certain that legislators do not have standing to challenge statutes merely because they vote in the legislature.
No,
But we'll leave that for another day.
Yeah, they're bringing in their individual capacities, Your Honor, so thank you. Thank you, everyone.
Mr. King. Again, because everybody's come and taken their time, because you've waited till the end, and we don't want to be like the trial court where you have no time to do your case because it was set for 2 days and it's now 3 o'clock on the second day.
And you came from Butler
And
County.
you drove
so-
all the way from Butler.
Thank you all.
We'll let you go, but I would admonish you to stay on the point, because I'm not going to give you quite as much leeway as I have the prior counsel.
Yes, Your Honor. That may please the court, Mr. Chief Justice and Justices of the Supreme Court of Pennsylvania. I'm Thomas W. King III of the law firm Dillon McCandless, King, Colder, and Graham of Butler, Pennsylvania, Butler County, Pennsylvania. And so I'm pleased and honored to be here. I wanted to note also, by way of cordiality, that both Mr. Bonner and Mr. McLinko are here today. And so Representative Bonner is a lawyer and is seated at the council table behind us. Mr. Bonner is an honored member of the bar of this court. So I wanted to introduce both of them to the court. I would also like to not repeat, hopefully, all the very fine arguments of my co-counsel here. Professor Domino did a wonderful job, I think, in addressing the historical analysis of Chase and Lancaster City. And I think there have been extremely interesting arguments that have been raised, the import of Section 4, and whether this is the first instance that you'll have to address Section 4 or not is certainly up to debate. But I looked at this from a different perspective. And so one of the things I looked at was how did it come to pass that that other than the 4 instances that took place in the modern legislature, how was this Constitution always amended? There were always amendments to the Constitution. They were voted on by the voters of the Commonwealth of Pennsylvania. And so I began to look back to, for example, the Pennsylvania Election Reform Task Force. This is a task force that was convened by Governor Ed Rendell. Governor Ed Rendell convened a task force in 2004, led by Pedro Cortez, who you all know to be a very fine public servant who was the Secretary of the Commonwealth. And so I look back to see what did this task force have to say, because there have been lots of conversations in Pennsylvania about mail-in voting. And this task force made a recommendation in 2004 addressing first and foremost the idea of mail-in voting. The recommendation was that the Pennsylvania Constitution, if necessary, and the Pennsylvania Election Code should be amended to eliminate all reasons or conditions necessary to qualify for an absentee ballot and permit any qualified elector to vote by absentee ballot without excuse. No excuse absentee ballots. So I commend to you if you have the opportunity to take a look, there are many instances, many references throughout this document. I won't read them all to you. Many references throughout this document to the need to amend the Constitution to institute no excuse mail-in voting. In addition to that, there's a notation, and this leads into Mr. Justice Weck's question, which I think is extremely important, and that is, and so what I did to get to that question is, I asked myself, how did our neighbors in New York get to vote on a constitutional amendment to the Constitution of New York? What happened in New York that was different than Pennsylvania or similar to Pennsylvania? And so when I went to the Constitution of New York, I went to see how was it that they amended the Constitution. And so this addresses Mr. Justice Weck's question about what would you need to do to have a constitutional amendment here. And what I think you would need to do is to look at the example in New York. And I think that you could also look at the bill that was Senate Bill 411, introduced in part by my esteemed colleague, Senator Jay Costa, who I noted in a footnote in good humor, by the way, since I've been co-counsel with Senator Costa on other matters on the same side. So I wanted to look at that. What did the legislature start to do here? What they started to do here was they introduced a Senate Bill 411. 411 became part of 413. And ultimately, these Senate bills gave way to an action by the legislature to simply legislate mail-in voting. But when they did look at whether the Constitution needed to be amended or not, Senate Bill 411 and Senate Bill 413 specifically would have stricken the language of Section 14 of Article 7 of the Constitution. And so I went to New York to see what happened in New York. How did they do it in New York? And I think what I found to be extremely interesting, I'm going to refer to...
Can I just interrupt for a second? Some people may not understand why you're bringing up New York. We all understand, but some people may not understand. So New York does not allow mail-in voting? Or
Yes, sir.
Right.
Yes, thank you very much. I appreciate that, and I think it's probably a good idea to let everyone know why we're talking about New York. So the reason we're talking about New York is because it just happened. In New York, 1,600,000, and this is where I depart a little bit from Judge Levitt, who, by the way, did a wonderful job. Judge Wojcik, even in his dissent, complimented Judge Levitt for the exemplary work that she did in her opinion. It's a fascinating piece that I would commend to anybody's reading to garner a knowledge of the Constitution of Pennsylvania. But in New York, what did they do with respect to Mr. Justice Weck's question? What did they do? They struck the absentee voting provisions. And so I would suggest to the court that it is extremely important to look at not just this concept of offer to vote, which can be debated as to the section that it's in and whether it's a condition or whether it's a description. And so in looking at Article 7, Section 14, and when you read that section, and it's a little difficult to get through, but it says that the legislature shall, and we've debated shall and may, and I'm not going to go into that. My point, rather, is to look at what is it that Section 14 of Article 7 does. And then I want to tell you from a practical standpoint how that relates to Pennsylvanians and how we vote and what people think in this state. And so the legislature shall, by general law, provide a manner in which, and the time and place, at which qualified electors who may, on the occurrence of any election, be absent from the municipality of their residence. And so this was Mr. Justice Doherty's question about you have to be out of your voting district. So it's not just out of your voting district, with all due respect, Your Honor. It's not just out of your voting district. It's absent from the municipality of their residence because of their duties, occupation, or business require them to be elsewhere, or who, on the occurrence of any election, are unable to attend at their proper polling places because of illness or physical disability, or who will not attend a polling place because of the observation of a religious holiday. You've seen in one of the amicus briefs the legislative history of Representative Ivan Itkin, who some of you from Pittsburgh will recall. Ivan Itkin addressing the need to include in the Pennsylvania Constitution a religious holiday exemption from voting. But this section goes on to say, because of the observance of a religious holiday, or who cannot vote because of election duties, in the case of a county employee, may vote and for the return and canvass of their votes in the election district in which they respectively reside. I suggest to you that this section is at least as important as anything else in this case, because what it does, in my opinion, is it sets a ceiling. That's the ceiling for how you can vote other than by appearing in person at your poll. And for many years, six of the members of this court were elected by people having to go to their polling places. One member of this court was elected by both going to the polling place and having mail-in voting. But we all know that historically in Pennsylvania, voting has been in person. And so the only exceptions to that, as I think the Chief Justice mentioned earlier, the only exceptions to that were those provisions set forth in section 14, which is the absentee voting provisions. And when we say absentee voting, we mean absentee in the sense of both you are away from your place of residence, or you may not be able to get to your poll. So in the instance where one of the amicus briefs on the other side, in this case to address people with disabilities, so people with disabilities are covered by the provisions of the current Article 7, Section 14 provision. And so absentee balloting has taken place for a long time in Pennsylvania.
May I ask you?
Yes, sir.
No matter how much you study a case, sometimes something just pops out. And I was going to admonish you to not read Section 14 to us because we've all read it 20 times. But I'm glad I let you do it.
I appreciate that, Your Honor. Thank you.
Section 14, at the conclusion, it says, "and return and canvass their votes in the election district in which they reside." There's no doubt that these are absentee ballots specifically authorized by the legislature, and yet they're to be returned and canvassed in the election district where they reside by absentee, therefore by mail. So doesn't that read consistently with, and again, I'd never thought of this before, I'm thinking out loud, with Article 1, Paragraph 3, that the language offer to vote means to return and canvass the vote in the election district where they reside, regardless of whether it comes by submarine or by mail?
Mr. Chief Justice, I'm so pleased that you asked that question because I'm going to tell you that Act 7, one of the significant problems with Act 77, and I got to tell you, on Election Day, I'm in the counting houses, I'm out at the polls, I'm in a lot of different places in my role as the General Counsel for the Republican Party of Pennsylvania. And much as my colleague and friend Cliff Levine, who's here today, does the same thing. And so sometimes Cliff and I are in the same place trying to work through things like the 28,000 bad ballots that got sent out in Allegheny County. I spent a holiday weekend with Cliff in Mr. Zeffie's office trying to resolve that.
Over a drink one night. Answer the question for
Yes, sir. I did get a bit of field. I apologize. But to answer your question, under Act 77, these ballots are going to a central counting location. They, along with the absentee ballots, are being counted somewhere other than at the polls and at the location that's provided by under Section 14. That issue is not before you today, but as you read it and as you saw it, I was thrilled that you noticed that, because that's not what happens under Act 77, and that's part of the problem of the lack of integrity that a lot of people in Pennsylvania think that Act 77 is missing out on. And so, what I hope I answered your question, but these ballots are not going to the poll, to the local poll.
Let me try one more time, and then we'll call it a day on this. What occurred to me, and as I said, I was thinking out loud, was that the last phrases of Article 7, Section 14, which describe how to return an absentee ballot in the districts in which they respectively reside, the last seven words or so of the section,
Yes, sir.
erode the argument that offer to vote says you have to be there in person to vote, because you can vote absentee in the same fashion under that language.
Well, I'm hoping that I'm making myself clear. But what's not
in my head, so do it again for me.
Yes, sir. What's not happening under Act 77, what's happening under Act 77 is these mail-in ballots are being counted somewhere other than at the poll. And the
Counted at the Bureau of Elections, the County Bureau of Elections, right?
Yes, ma'am. But they're not counted at the poll. And that's what happened prior to Act 77. Prior to Act 77, if Madam Justice Donoghue or somebody else in the world was qualified for an absentee ballot, her absentee ballot would be mailed in, and those ballots would be actually physically delivered to the polling place, to her polling place. So someone would know at her polling place that she voted absentee. That's not happening under Act 77. And I believe that that's another challenge, that if this law, if it stands, that'll be the next challenge that'll be here, because that's not what's happening. And there's a real practical import to that, and that is when I vote in my polling place in Middlesex Township, Butler County, when my absentee ballot shows up, somebody knows whether I voted or not, and somebody knows whether I was absent or not. There's an opportunity for the people at that polling place to see them. And that's what happened in Pennsylvania all the way back to the time when absentee ballots were authorized. So I did want to get to this whole.
So much for privacy.
Well,
They don't know what you're casting. They just know that you.
well, yes,
So we got
the
it.
envelope-
Make your
yes.
Would be opened.
final point.
I did want to just say this. So when I looked at New York State again, and again, the reason we looked at New York State was because 1,600,000 people voted no. 1,300,000 people voted yes in order to, on the question of whether or not there should be mail-in voting in New York. It was a shock, I think, to everyone, but the vast majority of people voting in the 2021 election or 2022 election in New York, 2021 election in New York, voted not to approve mail-in voting. And so I went back to see how is it, to start my argument here today, how is it that in New York this question was even on the ballot? How did it get on the ballot in New York? And so what I found was the New York City Bar wrote a report, and the chair of the New York City Bar report committee was a member of the highest court. I think the Court of Appeals is the highest court in New York. And so the chair of that committee was a justice of that court who recused himself because obviously he had concerns about this matter appearing before him. But and I'll kind of sum up with this, if you don't mind, Your Honor. There are several points to be made from the report of the Bar of New York City. The report on, it's called the Instituting No Excuse Absentee Voting in New York. And I will tell you that in New York,
Would you sum up for me by explaining precisely, succinctly, why we care about New York?
here's why we care about it. We care about it because, and I think this goes to Justice Weck's question earlier, we care about it because the New York Constitution, similar to ours, has a provision for absentee voting. And so the legal canon that we follow, the inclusion of one is the exclusion of others, is the point that I'm trying to make. And so when we include something in the Constitution, such as absentee ballots under Section 14, when we include that, it's to the exclusion of other means or methods of voting other than arriving at your polling place. And so Section 14 is critically important. And so what I thought was at least interesting, Judge, what I thought was interesting was the analysis that the New York City Bar took is the analysis that I would take in arriving at a conclusion on this issue. They first found that New York law currently requires voters requesting an absentee ballot to provide an excuse for their inability to vote at their designated polling place. The only excuses in New York are unavoidable absence from the county of residence due to duties, occupation, business, or studies, or accompanying a spouse, parent, or child for that person's unavoidable absence, or absence due to vacation.
Mr. King, your point is, if I understand it, that we should read Article 1, Section 14 as the proverbial ceiling, because that's what New York did.
Well, I think you should look at Article 14. I just think it's interesting that New York did it, and I think they did it because when you read the report that they did, they have the same constitutional canons that we do. They cite specifically the inclusion of one as the exclusion of others, and they
Again, and I'm just trying to without being impolite, to make this a little shorter. The law of another state is not binding, but has persuasive value, and you say we should read New York, it has persuasive value, that Section 14 is the ceiling.
Yes, Your Honor. That's exactly what I'm saying.
Can I ask you, counsel, just to put differently, is it your position that if appellants are correct, then the existence of Section 14 makes no sense?
Yes, sir. And what I wanted to say about that is, I don't know how many times I've been asked. It's at least dozens and maybe more. Mr. King, what do I need? Do I need an absentee ballot or a no excuse ballot? And the answer to that question is the answer to this case. The answer is that there is no need any further for Section 14 of the Pennsylvania Constitution if you adopt the position that mail-in voting is allowed to be imposed by the legislature. Then the Section 14 would be eviscerated by an act of the legislature, which cannot stand in Pennsylvania, as you all know.
Unless someone takes the position that Act 77 is an exercise of Article 1, Section 14, or it encompasses all of the things of the right of absentee voting that the Constitution provides, and then some.
Well,
that wouldn't eviscerate it. It would mean Act 77 supplies the right.
Well, my point, I guess,
except for the point that the mail-in ballots do not go to the polling places.
They don't go to the polling place, but the point is, I guess, the canon that we all subscribe to and are bound by is that we cannot, an act of the legislature cannot eviscerate, those are the words of the cases, cannot eviscerate a section of the Constitution. And so, yes, sir.
Under Act 77, I believe subsection Z6, it specifically states, the General Assembly specifically states that qualified mail-in elector, that being no excuse, shall mean a qualified elector who is not a qualified absentee elector, and a qualified absentee elector is defined by Section 14. That seems to negate your argument because we're not, Act 77 is not undermining the Constitution. It's clarifying that now, based upon its application of method, anyone who is not absent because of business, however business is defined, may be that individual who is fearful of hypothetically a pandemic and decides to mail in ballot as opposed to stand in a long line in a cloistered election district. Would it be that way? And if so, why would the General Assembly specifically separate a qualified elector to be different than a qualified absentee elector, knowing we have subsection 14?
I would respectfully suggest, Your Honor, that perhaps somebody drafting that act would recognize the very argument that I'm making at this point, which is this is a distinction without a difference. There is no one out there saying that some mail-in voter is not qualified to be a mail-in voter because they were away, or because they were celebrating a religious holiday, or because they were doing something else. So the careful drafting of a piece of legislation to attempt to deal with the distinction that I'm making is I can't ascribe that to anyone, but I can only suggest that the mere inclusion of that provision in that legislation doesn't make it so. I understand, Your Honor, but in a practical sense and in a legal sense, there is no distinction. The people of this Commonwealth, when asked whether they need a mail-in vote or an absentee ballot, there is no such distinction. And it literally eviscerates Section 14 of Article 7.
We understand your position. Justice Todd has the final question for the morning.
Well, since we're at the end of this argument, which has been very exciting for all of us, I just want to make it clear that you and your colleagues, if you prevail, are not seeking to invalidate any of Justice Brobson's mail-in votes that he received in November.
Justice Todd, thank you. I understand they're only seeking prospective relief.
Justice Todd, with all due respect, I wouldn't touch that question with a 10-foot pole.
Thank you very much.
Yes, ma'am. Thank you, Your Honor.
Thank you.
All right. We've been here almost 3 hours. Excellent argument by all of you. Thank you. Difficult case. Appreciate it. We're going to take a 45-minute lunch break. We'll come back on the bench at 1 o'clock and do our final 3 cases. Thank you all. Well done.
Thank you.
sorry for the delay. Try to hear every case completely.
We had to eat.
We're sure you had a headache also. In this case, several entities and individuals filed a petition for review in Commonwealth Court's original jurisdiction to invalidate the Department of Human Services' new methodology for reimbursement to providers who offer community participation support services to intellectually disabled individuals. DHS filed preliminary objections challenging, among other things, that the providers failed to exhaust administrative remedies. The Commonwealth Court agreed and sustained the preliminary objections, dismissing the petition in its entirety. The appeal was filed and we granted oral argument to consider whether the Commonwealth Court erred by dismissing the petition on the basis of exhaustion of administrative remedies. Also, in its responsive brief, the Department of Human Services raised the issue of standing. Accordingly, in the grant of oral argument to resolve the sole issue presented, we directed the parties to file supplemental briefs to address the potential impact of our recent decision in Firearm Owners Against Crime on the issue of standing, particularly, I think, as to the provider's umbrella organization and the two individual recipients of benefits. So if that explains where we are, Mr. Lucas, feel free.
Thank you. May it please the court, my name is Christopher Lucas, and I represent the petitioners in this matter. As the Chief Justice noted, this case arose from a challenge to fee schedule rates that were promulgated by the department for community participation services, but they were promulgated not in compliance with the administrative agency law and instead in reliance on Act 22 of 2011. We filed a petition for review challenging the constitutionality of Act 22 of 2011 based on non-delegation. And it will be important for the court to note that in the reproduced record at page 16 and 20 are paragraphs 52 and 67, respectively, of the petition for review that contain the language that we believe constitutes a facial challenge to Act 22 based on non-delegation. The petition for review also contained an alternative argument, and the alternative argument was that even if Act 22 was effective in delegating some rate-making authority, that the department exceeded the delegated grant of authority. And in light of the lower court's opinion, it might be helpful to think of these two arguments as a facial challenge to Act 22 based on non-delegation and an as-applied challenge based on the fact that the language of Act 22 itself only delegated rate-making authority for a single year. But the rates at issue are 2019 rates. So we would argue that the department exceeded the grant of authority from Act 22. As such, the petition for review presents pure questions of law that under the Arsenal Coal case are well suited, we believe, to judicial review. For the purposes of standing, there are three distinct types of entities that are petitioners in this case. As the Chief Justice noted, the first type are people who are profoundly intellectually disabled and who are ultimate beneficiaries of the fee schedule rates, which are used to pay community participation services for these individuals. These individuals are entitled to statutory protections under the 1966 Mental Health and Intellectual Disability Act and the numerous precedent out of this court establishing that the state stands in parens patriae with respect to these individuals and that the state must provide these services. Because of this, these individual petitioners fall squarely within the class of persons that Justice Wecht noted in the firearms owners case involve the core of standing is implicated when we're dealing with laws that might infringe on personal rights. And of course, in this case, we're dealing with the liberty interest of people with profound intellectual disabilities. In addition, these people are entitled to receive these services in the most integrated setting possible, the most integrated in the community under the Federal Americans with Disabilities Act and the 1999 U.S. Supreme Court case Olmstead and the many cases implementing that. I think that it's interesting, in Justice Baer, in his part of the opinion in the Firearms Owners Act case, he calls attention to what's really our sort of fundamental standing case in Pennsylvania, which is William Penn parking. And he calls attention to the fact that in William Penn, the tax was levied not on the operators of the parking garage, who were the petitioners, but it was levied on the people who parked there, the ultimate customers. Nevertheless, the parking garage owners were held to have standing because the tax was levied in a way that connected those two people or ultimately fell on the operators of the parking garage.
Again, it's a continuing theme. I don't want to be impolite. The putting aside standing for the umbrella organization and the two individuals for a second, the principal issue that I think we took the case, well, we granted oral argument on. We're stuck with the case because it's an original jurisdiction, but we granted oral argument, was exhaustion of administrative remedies. And in listening to your beginning, it seems to me that these are all arguments that can be made in an administrative hearing. You may be 100% right, but the question is, can you go directly to the Commonwealth Court and then to us, or do you have to go through the administrative process? So if you could explain to us, because the right to go to the court system is very narrow, you know that, that's what the case law says. And I think has to involve a facial, or at least as applied constitutional challenge, as opposed to DHS got it wrong.
Well,
So I think that's the first issue, and then the second issue is standing.
Thank you so much for bringing that up. I'm not 100% sure I understand your question, but let me sort of restate it. Which is
Assuming everything you say is correct, why can't it be made in the administrative tribunal?
Well, one of the things that I'm sure my colleague Helene Locks will agree on is that there is no administrative remedy available for these individuals, nor for the association. So this is one way in which the lower court's decision is completely deficient.
Can I stop you there?
Sure.
I think your opposing counsel would say to the extent that the association members are providers, they have an administrative remedy.
Well, thank you so much for bringing that up. To the extent that there's identity between the association and members, and all of these members, so 100% of members of the association have this administrative remedy, yes, I would agree with you. However, what I'm going to demonstrate to you in the course of my argument is that that's far from the truth.
Well, in the course of your argument, or are there facts of record, or that would support what you're going to bring our attention to?
Well, so it might be more in the nature of an offer of proof, but if you let me finish my argument, I think that some of these issues will be much clearer.
Well, let's just sort of make sure we have the argument defined. And I'm just, again, I'm not questioning the merits of anything. I'm trying to understand where we're going. Do you concede, did I hear you correctly, that you would concede that the providers, as opposed to the, and I wrote it down, Rehabilitation and Community Providers Association, that the providers have an administrative remedy?
I concede that in part. So some providers, the community participation providers, which is a small group of our CPA members, but there are some that do have an administrative remedy. But number one, it is not sufficient to just have an administrative remedy. The administrative remedy must be adequate. But more fundamentally, the lower court's opinion is in error because it doesn't read the Declaratory Judgments Act. So as this court, as justices of this court, Justice Donahue, in the firearms owners case, you brought up, in your opinion, Section 7533 of the Declaratory Judgments Act. And you noted that the standing, if you just read Section 7533, there's just a straight statutory construction issue. What does it say as to who has standing? And that standing bar is extremely low. It says interested person or someone whose rights are affected. It's a very low bar. Furthermore,
I'm really trying. The issue of standing and the issue of failure to exhaust administrative remedies are distinct. And if I understand your argument, again, and I'm really trying to understand where you're going, you're arguing that because they may have standing, a direct, substantial, immediate interest in the litigation, that they don't have to have administrative, that they can bypass administrative remedies and come directly to the Commonwealth Court. Is that what you're saying?
I'm saying that the outcome of the administrative remedies argument depends on 3 and only 3 sections of the Declaratory Judgments Act, read plainly and simply. And those sections are 7533, a declaratory judgment can be brought by any interested person, anyone whose rights are affected. Section 7537, which specifically says that the existence of an alternative remedy is not a grounds for the trial court to dismiss. So if we accept the premise that there's an administrative remedy, that in and of itself is not sufficient for a court to deny standing under a plain reading of Section 7537.
The Declaratory Judgment Act.
Yes.
Thank you. So I think I understand your argument. Go ahead.
And then and if I can follow up, and that's one of your claims of error, your principal claims
Yes.
of error with respect to the Commonwealth Court's ruling.
Yes. So, and if we could go just into the Act to one more section, which is 7541 C2. B and C2. B is, what is the effect of an alternate remedy? The legislature told us, they told the courts, here's what you should do if there's an alternative remedy, which the lower court seems to think that there is. And what it says is that the effect of an alternate remedy does not defeat the ability to bring one of these cases unless, and this is C2, there's a single exception, and that exception is when the claim is within the exclusive jurisdiction of the other tribunal. The exclusive jurisdiction of the other tribunal. So if I bring a petition for review and I challenge the facial constitutionality of an act of the General Assembly, or in the alternative argue that the administrative agency exceeded any authority that was delegated, there is no administrative tribunal in Pennsylvania vested with exclusive jurisdiction to hear that. Under the Judicial Code of Pennsylvania, that tribunal is the Commonwealth Court of Pennsylvania. That's who hears those cases.
And if we distinguish between a facial constitutional challenge and a challenge that the department did this wrong, not that it's unconstitutional, that it's to use the case as the hypo, that it's an unpromulgated regulation. You would say if you bring a DEC action, you've chosen not just your remedy, but you get your forum. And you can make the latter argument, the unpromulgated regulation argument in Commonwealth Court.
I would agree with that, and I think that that's consistent with the reading of Firearms Owners Act, that the Declaratory Judgments Act is a remedial statute. If it truly is a remedial statute, it should be read liberally. But we don't even really need to get there. If you read the 3 sections of the Declaratory Judgments Act that I cited to you, the conclusion that the lower court is in error in its attempt to read into the case law a distinction between facial constitutional challenges and constitutional challenges as applied is just inapposite. If there is such a distinction, it's not relevant given the plain wording of the Declaratory Judgments Act
Counsel,
itself.
I mean, your argument is an argument that I've heard before, but we still have the jurisprudential principle of exhaustion of administrative remedies. that coexists with the Declaratory Judgments Act. Now, you're not arguing that we completely get rid of the doctrine of exhaustion of administrative remedies because the Declaratory Judgment Act says what you're saying it says.
Well, I'm probably 80% there. So in terms
Again,
of,
this isn't the first time I've heard this argument,
well,
but
I maintain that the language of the statute is clear and that the General Assembly's grant of authority or constraints on the remedy that it gives in the statute are controlling.
what happens when the General Assembly gives a more specific remedy than the Declaratory Judgments Act to address the particular challenges that a party is seeking to raise by virtue of the Declaratory Judgments Act? Should we default to the specific administrative remedy that General Assembly has created over the more general remedy of the Declaratory Judgments Act?
I would say that there's no question that there's this, big separation of powers issue, and that courts protect their own jurisdiction. There's no question that the court has the ability to exercise prudential judgment to operate the court system. No one is argues that that's not so. However, where not a common law or not something that was existing in 1789 when this court became part of the state of Pennsylvania, if we're dealing instead with a special statutory remedy that the legislature itself gives, then the legislature itself controls the terms on which that remedy will be given and the terms on which every court is to construe the remedy. And the Declaratory Judgments Act does that. And I would argue that courts are bound by that. It's not a common law remedy. If it was a common law remedy and it existed in 1789, if it was an equity, I think there would be some different mechanics here. But where this is a statutory remedy passed in the 1920s, we have to apply it as the legislature plainly provides. And that's quite broad, quite broader than existing jurisprudence.
So you're saying then that standing is really the only issue?
It is the only issue. Well, I do have an argument at the end. I do think the court might want to look at Rule 1028 and the record in the case. But if I could just continue on the standing issue, because I think what we've done now is what you've heard what I have to say about the lower court's opinion. But the lower court didn't rule on, or appears not to have ruled on, the standing claims of the individuals and the association. So we don't have a record, they didn't do a fact hearing, but you might consider my argument to be in the nature of an offer of proof in the event that this was remanded with instructions that they do a fact hearing. Because under the official note to Rule 1028, the official note under Rule 1028 says, if there's a preliminary objection under 1028A5, which is the capacity to sue, in other words, the standing part of the objection rule. If there's an objection there, the official note says lower court should do a fact hearing. But we didn't have any fact hearing here. So the record in that respect is somewhat deficient. But I have things to say on that. You might consider them in the nature of an offer of proof.
Well, I'm not sure respectfully that we need it. I think we understand your first position, which is that notwithstanding a robust area of law that says that, absent a facial constitutional challenge, I think that's what it says, or substantial constitutional challenge, I think it says, you have to exhaust administrative remedies, and you say not so, that fails to consider the Declaratory Judgment Act. If we file a declaratory judgment, we don't have to do that. And I understand that question. And then the second question, if I understand it, that we asked you to argue is whether or not the Commonwealth Court erred by dismissing the two individuals, Mr. Brent and
Mr. Brett and Mr. Schwartz.
And whether it erred in dismissing CPA, I think you referred to it.
The Community Providers Association.
Because even assuming arguendo, that you don't need this argument if you prevail in your first argument, but assuming in arguendo that we're going to say you do have to exhaust administrative remedies. Those three don't have administrative remedies.
Correct.
Okay.
Well,
Why don't you,
And part of that is built off of your new position that you didn't plead in your pleading, that the Community Providers Association isn't just an association of providers.
I do believe it's, so I'm going to defer to our written brief and to the petition which speaks for itself, but the pleading is quite detailed. Now, it might not be as excruciatingly detailed as I'll get today preparing for this argument, but it goes much further than just providers.
We've already read the excruciating detail of your petition for review.
Okay, so yes.
But I think I think to understand what sort of the baseline situation is, the Commonwealth Court sustained preliminary objections on exhaustion with regard to all respondents without separately analyzing whether each particular respondent had an administrative remedy to challenge the reimbursement rate.
True.
Okay. And your appeal is twofold. One, as far as the providers go who had a remedy to appeal the setting of the administrative setting of the rate, which you acknowledge they have a remedy, with the exception of them, it was improper for the Commonwealth Court to dismiss on exhaustion the individuals who do not have the right to appeal administratively the setting of the reimbursement rate.
Correct.
And then your third point is, with regard to community providers, yes, although they are an association of providers and therefore can only have the standing of their members, that works to knock them out on exhaustion for purposes of the providers, but it doesn't work to knock them out on exhaustion for purposes of the representation of the people who are getting the services.
True. I'd like to be able to try to make my argument on it because it's more nuanced.
Okay.
The Community Providers Association is the umbrella that encompasses the sum total of all the legal it represents all the folks that form the legally required community integration. And so we're not just dealing with providers, we're dealing with psychologists and physical therapists and MDs and day programs and all kinds of others. So, number one, the makeup of this organization is much more Catholic than the simple assumption that, well, it is comprised of a bunch of people who could file their own individual administrative appeals. That's not so. Furthermore, the association itself furthers the goals of the community integration by operating things like shared risk pools for workers' compensation, general liability, group purchasing arrangements. All these kinds of things are impacted by and suffer from inadequacy of rates on individual groups of providers within that group. So the association itself is fiscally hurt when something like this happens because all the administrative costs and the group purchasing arrangements and shared risk pools, those all shift as groups of...
If the providers, if you lose on exhaustion, providers go down and in the administrative remedy, they prevail, the association's problem is cured because all the money flows to the providers and ergo to the association. Yes?
Well, in an ideal world, I would say maybe that's so. I would call attention to some important change in the law that some members of this court might not be aware of, which is that from the inception of I'll say the Medicare and Medicaid programs in 1965 until just recently, the federal government, but also all states, including Pennsylvania, operated this program on a fiscal year basis. And so rates would be published in the PA Bulletin in anticipation of the start of the July 1 fiscal year, and those rates would be in effect for one fiscal year. That is no longer the case. The department, as to these rates, has moved to a 3-year rate cycle. This is incredibly significant for Chief Justice Baer's argument, because what it means is, before we get to any administrative remedy, we have to withstand fiscally not 1 year of inadequate rates, but 3. And this stretches this administrative remedy out to a point where, and this is sui generis in our law, we have never had human service organizations reimbursed on 3-year rate cycles. But this puts these providers under extreme duress. And at a fact hearing, I'm confident that we could prove that it's an inadequate remedy if we have to wait 3 years to file the appeal.
You know, there are a lot of administrative remedy schemes in the Commonwealth of Pennsylvania that takes years to resolve to get to the courts.
Well, I certainly do. I've been practicing this area for 25 years, so yes. But I'll tell you this.
And that's not,
This-
that's not an exception to the
No,
exhaustion.
no, it's not. But here's the distinction I would make. I'm not talking about how long it takes to resolve. I'm talking about how long it takes until you have standing to file. Because you don't have standing to file until you have some kind of a loss or some kind of an inadequacy. And you can't establish that until the rate cycle has ended, because conditions could change.
You can't, as soon as they establish the rate, you don't have a clock ticking to appeal your
No,
rate?
because the procedures that the department operates their administrative body by require you to prove damages. You have to prove damages. So let's say on day one, let's say June 30, they publish the new rate, and I appeal on July 1. I am going to get a practice order, the case is going to begin to move, and I will not be able to analyze the impact of 3 years of that rate until 3 years have passed. What would I ask for? What would I say? Would I say, hey, I think that 2 years from now my costs will be X, and 3 years? No, I can't do that. So when the department moves to a 3-year rate cycle, they have fundamentally changed the adequacy of this remedy. And it's a very serious issue and a very serious change in the law.
Would you be nice enough to mention the issue of whether or not the two direct recipients have standing to be in court?
Yes, yes, Judge. So, Justice Bear, so what I was saying was that these folks have standing under William Penn parking, and they have standing for the same reason that Justice Bear wrote about in the firearms owner's case. So Justice Bear notes, hey, in William Penn parking, the parking operators appeal even though the tax isn't levied on them, but they still had standing to pursue a declaratory judgment because ultimately they bear the consequences of the tax. In this case, although these individuals don't receive some kind of special funding directly from the government, they are in a contractual relationship or a caregiving relationship with entities that do. So when the department alters the payment structure or the fee schedule, it is affecting the relationship between the intellectually disabled person and their caregiving system in the same way that the tax in William Penn parking altered the relationship between the parking operator and the individual cars that have to pay the money in the parking system. So I would argue that, furthermore, that because we're dealing with people who have a fundamental liberty interest in integration into community settings that is set forth in mounds of law on our 1966 Act and the ADA and so on, these people kind of are analogous to the Second Amendment people in the firearms owners case. So the firearms owners are arguing, we have some Second Amendment right to carry our guns and stuff. These people have a fundamental right, a liberty interest, to be in the community. And if the rates are inadequate and we don't afford them standing to challenge those rates initially, infrastructure, community support infrastructure that takes decades to build can be destroyed. And then what? Do they have standing at the end of all that when their program goes away to, I don't know, bring some kind of lawsuit? It's so much more efficient, and I would say directly in keeping with the actual language of the Declaratory Judgment Act itself, to allow these people to challenge these rates up
Your
front.
argument isn't just that it's more efficient, it's that things will become irretrievable, right?
Yes, that there be, the damages to their fundamental rights will become unable to be remedied.
And it doesn't seem to me, tell me if I'm wrong, that you're arguing firearms. I think firearms is actually very distinguishable. You're arguing a much more straightforward that they have substantial, direct, immediate interest in this money because without it, their liberty interest, as you say, their right to live in the community is challenged.
Well, Justice Bear, I couldn't have said it any better myself. Perhaps there is some roundabout way of comparing the two, but I'm not going to argue.
What is the immediacy? I mean, do we need a record on this? Like, I mean, is there really, is there really, if this appeal is not entertained now, on what basis can we conclude that the walls are going to crumble down and that the community providers are going to cease providing the services that they've been providing these two individuals all along because of this rate change?
An excellent question. Ordinarily, that's something that would require the development of a record. But this is something that was thought through, and if you look in the reproduced record at the First Amendment petition for review, what you will see is that this was filed some months after these rates were promulgated. And what that allowed us to do is to take some accounting experts and take these rates and all of the units under every rate as they're billed and so on throughout the association, as well as all of the costs, and do a forensic analysis. So in the pleading itself, and now at this stage, of course, we're entitled to the benefit of inferences from our pleading. And this pleading is excruciatingly detailed to show you, code by code, what the deficiencies are, and they range between 7 and 54% of costs of efficient and economically run providers. Now,
So now I'm confused, because you told me that without a 3-year look back, you couldn't have evidence that the rates were inadequate and couldn't proceed with your administrative remedy. Now you're saying that in your petition for review, you provided expert information that shows that these rates are clearly inadequate now, and we can prove them now in the Commonwealth Court, but we can't prove them somehow in front of an administrative agency.
well, what I would say is we have one fiscal quarter, so we can show here's our loss for a fiscal quarter. We could trend that forward. But in terms of administrative agency law, we could never, under any administrative agency law system, state or federal, recover dollars from the government on estimated damages. We have to have certain damages.
Well, okay, now you're talking about damages. Now,
Well,
now we're
okay,
moving,
whatever.
but
A shortfall.
you
We have to have a number.
But you can't, I agree, this issue of whether you can recover damages in an appeal of an inadequate rate is a completely different question. The question is, are you challenging the rate, which I read your petition for review as a challenge to the rate because they didn't follow the Commonwealth documents law and all this other stuff. And you do, by the way, have a couple of paragraphs about the constitutional provision, but you're really seeking to challenge the inadequacy of the rate. And that is something that clearly administrative agencies can provide a remedy for, a rate inadequacy. Maybe they can't provide damages, but that's a different question.
I would respectfully disagree with your characterization. So as an administrative agency lawyer, when I'm filing a petition for review in the Commonwealth Court's original jurisdiction, I am looking at standing. Standing. That's the thing. So when I'm looking at defending a standing case, I want every judge that looks at that to be able to see the concreteness, the immediacy, and the definitiveness of that. In fact, in firearms owners, Justice Donahue noted that the declaratory judgment is available where there's concrete and immediate impact at the time of filing. At the time of filing. I wanted that filing to demonstrate beyond any doubt to a court that these people are suffering now. This is not a hypothetical. We're not imagining damages. This is happening now. But that's still a far cry from being able to go to final judgment in an administrative agency tribunal. We're not going to be able to do that to the end of the 3-year period.
I think we understand your position. Any questions at all from anyone? Would you like to?
Chief Justice, may I just
up?
have a moment to address Rule 1028? I want to make sure that the court notices the reproduced record at page 46A. This is where the preliminary objections for Mr. Schwartz and Mr. Brett are, as well as the association. That preliminary objection says, and I'm just quoting now, do not have standing to maintain this action. That's it. It's a bald legal conclusion. It doesn't have a single fact. We preliminarily objected to that PO. We don't think it meets, because the comment, the official comment to Rule 1028, anticipates the need of a fact hearing when you challenge someone's standing. The idea that litigants in Pennsylvania courts can trigger the expenditure of court time and energy on fact hearings with a simple legal conclusion, you don't have standing, to me this is problematic, and the shortest and easiest way to dispose of this case is to use the de novo review that you're making to simply conclude that this is not an adequate preliminary objection, it's overruled. Once you do that, this case automatically moves forward. You could reverse the lower court with instructions for the case to move
You
forward.
filed preliminary objections to the preliminary objections?
I do. They're
Let's
at, they're
file
at the
preliminary
reproduce,
Objections to preliminary objections to preliminary objections?
they're in the reproduced record. Ours are at 56A. And I would note that the lower court took these into account. The lower court judge noted in her opinion, she characterized the department's POs as succinct. But nevertheless, she went on to rule on them. My law firm has not been able to find a single Supreme Court case, a single reported case from this court ever, construing the pleading requirements for a preliminary objection to standing. Now, there is a Superior Court case, there's a couple of Commonwealth Court cases. They're very favorable to us. They're cited in our materials. But I would submit that the shortest and easiest way to deal with this case is to simply issue a decision on Rule 1028 that just simply saying someone doesn't have standing is legally insufficient, and therefore it's struck. Once you do that, it's easy to reverse and move from there without any kind of complex, analysis on these other much more difficult issues. And that's all I have. If there's,
Thank you very much.
thank you.
Ms. Lux?
Good afternoon. May it please the court, I am Helene Eichenwald-Lux, and I represent the Department of Human Services. I want to begin by addressing a question asked Mr. Lucas very early on in his argument about whether or not he will concede that there's an administrative remedy. In fact, in paragraph 15 of the PFR, exactly that was done. Paragraph 15 states, moreover, while these providers have the right to appeal the sufficiency of their rates via the Bureau of Hearings and Appeals. So, of course, I believe the Commonwealth Court correctly found that providers had an administrative remedy that they failed to exhaust. There's not really a constitutional question at issue. Appellants are not asking that a single law be declared unconstitutional. Rather, appellants state in the first paragraph of the amended PFR, this action seeks declaratory and injunctive relief in validating a new payment methodology because it is an unpromulgated regulation and unlawful under federal law and inconsistent with the federally approved payment methodology. I also want to address Mr. Lucas's claims about what kind of association RCPA is. That's the Providers Association. It stands for Rehabilitation and Community Providers Association. All of the individuals Mr. Lucas identified as being members of RCPA are not included in the petition for review. Nor does the PFR include any allegations how these alleged members were harmed.
What would have to happen, in your view, for these individual appellants to have standing?
For the individual appellants, and I just want to clarify, you mean Mr. Schwartz and Mr. Brett? They would have actually had to allege some kind of harm to themselves or have been harmed. Obviously, we don't think that there's any kind of harm to them. What they have alleged...
Why aren't they harmed when they don't get the money they need to live in the community?
That's not true that they don't get the money they need to live in the community. The money doesn't go directly to them. The money goes to providers. There are many, many, many providers of community participation support services. All those providers have an administrative remedy if they don't like their rates. Not every provider has appealed.
So you're talking globally. The issue being, what I infer from what the question being asked is, how are they not being harmed if they have a particular need and the agency that is providing that particular need in the home can no longer sustain operation because of the cuts for which they cannot allege they're hurt for 3 years down the road. So they decide to close up shop, and there's no one else in their town or in the county of, say, Cambria, that caters to their intense need that only Organization A. That's the question. We got it, but if I have autism, I can't go to the Cancer Society.
Sure. So I want to clarify, I want to point out that there's no allegation in the amended PFR that there is nobody else that will serve these individuals. The only allegation is that their preferred provider may, not definitely, may not be able to continue to serve them. There are many providers of community participation support services. And in fact, I just want to point out that despite the upheaval of the past 2 years, these two individuals are continuing to receive their services from Association Production Services. I may have misstated the name of their provider. I apologize.
Are they receiving the same services? Are they
I can't answer whether or not they're receiving the same services because they were receiving facility-based services, and we've had to make changes to facility-based services because of the pandemic. So,
Let me just see if I understand those. I understand Mr. Schwartz, for example, Mr. Gill, they were in a wonderful position where they could become acclimated in the community and work with people who didn't have any mental health disabilities and essentially work for a living. They were paid for the services they were providing, and I use that word, they weren't providing services, they were doing work, and they were being paid for it, and which is a wonderful experience for someone who otherwise doesn't get that kind of feedback on what they're doing. Are they getting that type of service?
I don't know specifically what they're getting right now, but I do want to clarify that they were not working in a community. They were working in a facility, in a sheltered workshop. So I can't, the reason I'm hesitating so much is I don't want to say something that isn't correct. And because of the last 2 years, we've had to make changes to sheltered workshops because of COVID-19. I don't want to say that for the last 2 years they received exactly the same services. They are still being served by the same provider, and they should, to the best of my knowledge, be doing exactly what they were doing when this lawsuit was filed.
Isn't your argument, again, I apologize, I'm a lawyer, and I think like a lawyer, it's been too long, that they don't have a substantial, direct, or immediate cause apropos the money, because the providers, they get their money from the providers have the right to the money. It's like, I'm not happy with the baseball strike, but I can't sue Major League Baseball. The Pirates have to do that.
Exactly, or the analogy that has been in my mind is Department of Health shuts down my favorite restaurant. I can't sue. I might be unhappy, I might be sad, I might be disappointed, but I don't have a substantial harm that gives me standing to sue.
Except in these cases, the individual will be forced to live in a facility as opposed to enjoying the community, unlike your ability to go to another restaurant.
That actually is not true. There are other providers. There's no allegation in the complaint. Let me start off with, there's absolutely no allegation in the complaint that individuals would have to move to the community if their provider shut down. As I've said, there are other providers who can serve these individuals in the community.
But the waiver program itself was created by your organization for the purposes of reintegrating individuals out of placement into the community. Now we're discussing, or you're defending, why the rates that have been created to get the people out of facilities into the community now are going to be cut short, and defend that the purpose is, well, we have more than one community that they can go to. Is that what you're arguing to me?
No, so the rates that are at issue are the community participation support rates. These rates help individuals. Actually, let me pull out.
I'm very familiar with them as a
Okay.
former administrative judge in Philadelphia's family court.
Right,
I worked hand in glove with dealing with community rates and waivers. So that's why I'm interested in your argument. It seems to be a complete policy shift from what your organization had pushed forward since Estelle Richmond was in the office.
And it's not at all. What Estelle Richmond is, what Secretary Richmond was pushing forward, and what is now actually required by the federal government, is to step away from these sheltered workshops and for people to be served within the community. They should be looking for community integrated employment as opposed to being segregated in a sheltered workshop.
So the question I asked is, share with me how it's not in conflict with the policy shift for purposes of waiver, for purposes of receiving these monies to get into the community.
I'm not sure I understand the question.
The question is, what is it that you're actually trying to ask us to do? Let's put it that way.
Well, I'm trying to ask you to affirm Commonwealth Court's decision.
Right. And why?
And why? Because providers have an available and adequate administrative remedy. It is providers that are harmed by rates, not individuals who receive services from providers who have choices of other providers, and these two individuals could at any time say, I'm not happy with the services I'm getting, I want to go to a new provider.
Individuals, I'm sorry, one more question. These individuals belong to an association made up of providers, or they're the individuals whose providers make up the association. Do they have standing then?
I don't believe, the Provider Association, I don't believe has standing because the providers have an administrative remedy, and the Provider Association can't substitute itself for its members. So in other words, if we allow the Providers Association to have a standing in the future, two providers who are unhappy about a rate can say, let's form an association and go directly to Commonwealth Court. We no longer need to exhaust our administrative remedies and totally eviscerate all the benefits of having to exhaust an administrative remedy.
Counsel, could you respond to your opposing counsel's arguments regarding the provisions in the Declaratory Judgment Act that say that having an administrative remedy doesn't preclude bringing a declaratory judgment action?
I don't agree that that's the reading of the Declaratory Judgment Act. In that point, I can just never again have to go exhaust administrative remedies. All I have to do is file for declaratory judgment, and I'm once again in front of Commonwealth Court.
I think that's exactly what your opponent wants.
Counsel, getting back to Justice Weck's question, because I don't think you answered it
Sure.
directly anyway, which was, so I do see this as a rate case, and people who get services, the important services here, or even services from insurance or utilities, it's a rate case, they're indirectly impacted. But if these particularly, and we're talking about the individuals here, not the providers, because the individuals, you would agree, do not have an administrative remedy, correct?
Correct.
Okay. So I guess the question is, if they had pled something along the lines of, our provider is X, our provider is now denying services to us, the reason the provider is denying service to us is because the provider says the rates are inadequate for purposes of getting our services. We are now being precluded from these jobs that we had that were part of this fantastic program, and there is no other way for us to get these services in our county. Is that adequate factual pleading to create a substantial direct and immediate interest for them to bring a rate case under the Declaratory Judgment Act?
I don't think it is, because I still think it's not their harm. I still think it's the harm of the providers.
But isn't that naive to say they're not harmed? They're derivatively harmed, they're indirectly harmed. How are they not at all harmed?
An individual, and I want to focus on what was actually said in the PFR. They never even say in the PFR, I won't be able to get my services. There's implications that maybe my preferred provider might decide to close, but I don't think you get standing based on implication. You have to allege a direct and immediate substantial harm.
Well, I understood your argument to be more globally, individuals are not harmed simply by virtue of the fact that the providers are harmed. When you have to acknowledge there is some indirect harm if the provider is harmed.
Right. I mean, take a step back then. My argument is really based on what is alleged in the amended PFR, because that is what we have in front of us.
Right.
You think,
But we issue opinions to cover what could go on in the whole state of Pennsylvania, not just in this case.
Well, I think it is unrealistic, really, to think that in the whole state of Pennsylvania there will be no providers. As the Department of Human Services, we are obligated to provide these services. So we have a huge problem if that situation is that our rates are really, in fact, so low that every provider is not providing services.
And
we will.
That, but you could imagine the case where certain providers cannot, and therefore there is indirect harm to the individual.
Right, but we have a duty to provide these services, and I mean, we'd have.
yes, Counselor, what is your position with regards to our decision in FOAC and standing?
With regard to firearms, I don't think it really applies. It's not a pre-enforcement action. The rates are already in effect. So to me, it's a totally different set of facts. And firearms does say that the regular standing, William Penn standing, still applies, and I think that's really what is issue here. There's no pre-enforcement. These providers are being paid these rates. They've been paid these rates since 2019, which also reminds me, I do want to address the statement of that you can only appeal the rates every 3 years. I'm not quite sure what the purpose of that argument was, but as soon as the rates are issued, providers can appeal them. So
I think your opponent was arguing that somehow, some way, the BHA will not allow them to move forward with the presentation of their case until they have 3 years of data.
That's absolutely not true. I have gone to BHA on many, 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 many rate appeals. They're not waiting for 3 years presentation of data, and in fact, many providers are taking a different approach and not showing their financial data.
Ms. Lutz, to maybe end this.
Sure.
As to the two individuals, notwithstanding that standing is, I believe, a preliminary objection, lack of capacity to sue, are they entitled to a hearing apropos of Justice Todd's questions to get on some sort of record whether or not they in fact have direct, immediate, substantial harm?
If there was a factual...
hearing and the opportunity to file affidavits, I know I'm pushing into summary judgment, but go ahead.
They could have filed affidavits and attached it to the PFR. Nobody has stopped them, and in fact, the original PFR had some affidavits. The amended PFR does not have affidavits. And as far as this is at the preliminary objection level, so we do have to take as true well-pleaded facts in the amended PFR.
And do they aver that they are losing their benefits?
No.
And we'll go read that.
Yeah, they do not. They imply, but they don't even make that kind of averment.
Any questions? Thank you very much for the presentation.
Thank you.
I put a question mark, I'm taking it off. I'm not sure.
Commonwealth, Pennsylvania versus Clayton Steve Wilson. Representing Mr. Wilson is Mr. Michael Ford. Representing Commonwealth is Mr. Daniel Sotis.
Thank you, please sit down. In 2004, Charlestown. Can we keep you on, Brian?
Brian Wilson,
Yeah, I missed one.
Commonwealth versus Wilson.
Sorry.
The numbers changed.
I got it. Apologize, I clipped through in my briefing book to the next case. I guess that was wishful thinking. Appellant seeks review of the Superior Court's order denying his petition for permission to file an interlocutory appeal as untimely, where appellant sought the appeal to appeal an order of the trial court dismissing a motion for reconsideration. Superior Court cited Menti versus Chevrolet for the proposition that a petition for permission to appeal an interlocutory order must be filed within 30 days of that interlocutory order, rather than from the denial of reconsideration. Appellants asked us to reverse the Superior Court, distinguish this matter from Menti based upon the fact that reconsideration was sought because of an intervening change in the law, our decision in McKellen, and the trial court specifically certified the case for appeal once the reconsideration was over. So if that's close, Mr. Cord, please feel free.
Mr. Chief Justice and the honorable justices, may it please this honorable court. I guess at the outset I'll say that I'm going to rely in large part upon my brief. I know this court has been here since it seems like 5 a.m. and I don't want to belabor this. The issue is laid out in the brief, but I guess I can concisely state that it comes down to this. did the Superior Court misinterpret or misimply mente in denying the petition for interlocutory appeal by permission as untimely? I would respectfully say it did. I'll start out by taking a bold position with this court by saying that there is no rule and there is no case that specifically precludes, in a case such as this, specifically precludes the filing for a petition of this sort, either pre-trial or during the trial, within 30 days of the denial of reconsideration or within 30 days of the Common Pleas Court certification of such petition.
Mr. Cord, may I ask you, because when I reviewed this case, I thought it might not be a good grant of aliquotter, with greatest respect. When did you file your appeal to the Superior Court?
The appeal,
And I'll lead you. I think it was on November 10th, but tell me if that's wrong.
that was November 6th.
Are you filed on November 6th?
Yes.
All right. My clerks found November 10th. We'll have to figure out that discrepancy. And you filed from, what, from an order of October 8th?
Yes, my notes, and I certainly would defer to this honorable court, the Common Pleas Court certified petition on October 8, 2020. My records show the petition for interlocutory appeal was filed in Superior Court on November 6, 2020.
And it makes all the difference, because on November 6th, you were within 30 days of October 8th. November 10th, you were not.
Yeah, that's correct.
Fair enough. Go right ahead.
And
I'll have to straighten that out in my offices.
thank you very much.
I'm sorry, now I'm at sea here. Counsel, could you, I thought we're talking about an order that the trial court entered on July 17, 2020, and then you waited 116 days instead of filing by August 16, 2020, and I thought that's the crux of the problem here.
I thought so too, but I certainly want to directly respond to the Chief Justice's specific question, but I will jump to it at this point. The omnibus motion raising the issue of preliminary hearing hearsay was filed July 17 of 20, was denied July 17 of 2020. That omnibus motion raised the issue of habeas corpus motion required stemming from that hearsay at the preliminary hearing. 4 days later, July 21 of 2020, this honorable court issued its McClellan ruling. As a result of that, on August 6th, and for whatever reason, records also show August 11, a timely reconsideration motion was filed. That would be of 2020.
And that's not an issue. Your reconsideration motion was timely, right? That's not a question.
That's correct. That's correct. On August the 11th of 2020, Judge on the Common Pleas Court in Cumberland County, Judge Maslin, gave the Commonwealth 30 days to respond to that motion for reconsideration. On September 10 of 2020, the Commonwealth filed, on the 30th day, filed its response to that. 2 weeks later, September 23 of 2020, reconsideration was denied. Once reconsideration was denied on September 23 of 2020, 6 days later, I sought on behalf of the defendant the required 702B language certifying the petition. October 8 of 2020, that petition was certified by Common Pleas Court, and again, as my records show, November 6, 2020, the appeal was filed with the Superior Court. Jumping back to the point I would like to address, unless this court has any questions, I would certainly be able to answer them. I noticed that the Commonwealth, in its reply brief on page 7 at the top, indicates that Rule 1311B, quote, clearly states that a petition for permission for interlocutory appeal must be filed within 30 days of such interlocutory order. That's the verbatim language on page 7 of that particular brief. But I note that in reading verbatim from the actual rule, the rule in 1311 subsection A makes it clear that an appeal may be taken by permission under 702B for any interlocutory order of a trial court.
But not if it was already too late, right? That's the crux of this.
That is the crux of it, and I'll jump then to 1311B. Permission to appeal from an interlocutory order containing the required certification statement may be sought within 30 days.
Of what?
30 days of the date that that language, that order was entered.
Wait a minute.
Which order? The reconsideration denial or the original order?
Well, and that's the crux.
That's the trap for the unwary.
That's exactly right. And I would make the argument that it's not from the reconsideration, but it's from the date in which the court included the required language. Because in looking at the rules, that's why I started out by pointing out, in looking at the rules, there's nothing that specifically says directly on point that it must be. And I can see that if the Commonwealth makes the argument that there's a rule that specifically says under circumstances such as this, it must be filed within 30 days of that prior date, then I'm out of here. It's as simple as that, and I will concede that. But I would make the point that looking at the specific language of the rules, it doesn't specifically say that. And I'm curious to see, and I've checked 2, 3, 4 times in the Commonwealth's brief where it takes that position. But I'm not going to belabor this. I know this court has read all briefs extensively.
Could I jump in, counsel?
Yes.
Pardon me, sir. I'm trying to think about your argument. It seems to me that if McClellan had been decided outside your 30 days, then we might be on to something here, so to speak. But McClellan was decided about, I think, 4 days after the order, so you still had plenty of time to bring your appeal, to seek your interlocutory permission for appeal, and you didn't do that. You elected to file a motion for reconsideration. You had a right to do that, but that's the track you chose to go on. So I don't see how you can now, it seems like you want to get back on the 1311 track, but you went off that track, I think, when you filed for reconsideration. Can you explain to me why I'm wrong?
I would say that the court is not wrong per se. The point I would make is that in reading each of the pertinent rules, there's no mandate that it must be filed within that original date. I read the rules to allow a party, in this case the appellant, to file within 30 days of the date that the final order was received. But I'm not going to belabor this. I see, based on the court's questions, that there might be a difference of opinion. My position is simply that there's no specific rule and no specific case law that mandates the 30-day filing at the previous date. The way I read the rules, respectfully, it allows me 30 days from the date in which the 702B language was inserted.
I wonder if the nature of the recon matters. And bear with me for a second, but I think if you file a recon and maybe say, for all the reasons we said previously, Judge, you were just wrong. Nothing changes restating your argument. You're just buying time with a recon motion. But it seems to me that your reconsideration motion here was more than just, Judge, you got it wrong. It was almost an entirely new habeas, arguing that there was a change in law, that there was a change in precedent. And maybe the Common Pleas Court didn't get it wrong the first time, but in light of McClellan, you're giving them another shot at it in light of a change of precedent. And can we distinguish that kind of a recon, which is really more in the nature of a new habeas, than simply what we see too often, I guess even appellate courts, is please reconsider this decision because you were wrong?
My direct answer to that direct question is that this would be a new habeas if there had not been a change in the law. But because there was a change in the law, it was a different argument based on that change. Had the court ruled against me and I decided that, hey, with all due respect, the Common Pleas Court judge got it wrong, and come back to get another bite at the apple, I would concede this point. But it seems to me that I had something with the reconsideration that I did not have prior to the reconsideration. And
So it seems to me that Justice Brobson was agreeing with you, so you might want to...
well,
And I may help you also. Let me make just sure I understand this. I thought you filed your appeal November 10th and were out of the water, so I didn't concentrate as hard on all of this as I may have to. although I'm still going to go check and see when you filed your appeal respectfully.
Sure.
Under 1311A, it says an appeal may be taken from by permission from an interlocutory order certified under 42 Pennsylvania Consolidated Section 702B. That's what you have, is it not?
That is what I have.
You have an order that was certified. I guess and then there's no question that in B it says, you may take an appeal within 30 days after entry of such order being a subsection A order.
Yes.
And therefore, the question is, I mean, that's your argument, and the question is, it does say appeal may be taken by permission in both places. Are you taking appeal from such order, the A order? Does it refer back to July, or is it from the date of certification? And I don't know that the Pennsylvania courts have ever answered that question.
And that's why, well, I'm hesitant to respond because I understand that when Justice Brobson was asking the question, as Justice Todd pointed out, it seemed to be supporting my position. And I'm kind of digging a hole. So at this point, I think I want to stop digging the hole and simply remain silent. But to answer the question directly, in regard to the Chief Justice question, yes, the Common Pleas Court Judge of Cumberland County, Judge Maslin, did issue an order certifying the petition, and that was on October 8 of 2020.
And Mente did not involve a certified order.
That is correct. In fact, in Mente, the request for certification was denied.
Okay, and so you are solely standing on the 30-day appeal period attendant to the Rule 1311.
Short answer, yes.
Well, can I follow up, counsel? It seems that, reading between the lines, it seems you want us to create basically a new rule, and maybe such a rule should exist, I don't know, that when there's a case from us changing the law, that there's some new clock that starts ticking. The problem I'm having isn't with a hypothetical that should exist, it's with the fact that it doesn't exist. So we have this statute 702, and we have the Rule 1311, and that's what we have. And you had the time after McClellan to follow that track and didn't, and I'm still struggling to see how, in the absence of a different statute and a different rule, we can just sort of out of whole cloth now create a new clock to run. Can you take another cut at that one?
Certainly. I would respectfully argue that it's not so much taking a new look at it. It's simply to look at the rules as they exist. I take the position that the rules do not preclude. I'm not necessarily saying that, hey, there's this rule I can specifically point to that allows me to do that. My position is that there is no rule specifically that precludes the filing of a reconsideration motion and starting the clock afterward, as opposed to starting the clock prior to the reconsideration under circumstances that applied in this case.
You are not appealing from the denial of reconsideration, which is the way much of the opposing counsel's argument is framed. You're appealing from the grant of the certification. You're taking an appeal pursuant to the grant of certification.
That is correct. And I actually had notes with more comments, but again, I'm cautious about if you're digging a hole, stop digging.
Yeah, it sounds like an interesting assignment for our Rules Committee.
Thank you. Unless anyone has any other questions.
Thank you. Good argument. Thank you.
Mr. Sotis.
Good afternoon, Your Honors. May it please the Court. I'm Daniel Sotis from Cumberland County, District Attorney's Office. I'm here on behalf of the Commonwealth. I'm assisted by our certified legal intern, Mr. Mitch Snyder.
From which university?
Dickinson School of Law, Your Honor.
Welcome.
Have you followed the meanderings of the court in trying to understand this procedural question?
I do, Your Honor. And I did not bring an actual printout of the docket entries from Cumberland County, but the timeline that I constructed agrees with the November 10th date that the appeal had been filed.
My law clerks constructed it to be November 8th, so we have a
3 dates.
But, you know, I mean, in your I mean, I just pulled up the docket sheets that are in the record, and they seem to say November 10th, but I guess the real question is, what's the timestamp on the document say?
Weekend when filed and when adopted.
Correct.
But regardless of that, I mean, had appellant filed a 1311 petition for permission at the same time as a motion for reconsideration, this would be it'd be a different matter. I mean,
Yes.
assuming there was permission granted. For
Right. The long-standing, I think where you're going is the long-standing and historical rule reaching back, beginning in the 1970s, was, well, it wasn't fully articulated until much later, but the long-standing rule, even before Menti, was you can file them both. You can interpret. It's a contest between the trial court's ability and authority to reconsider its own judgments and to have that flexibility versus rules granting jurisdiction into the appellate court. And you can interpret both of those ideas consistent with each other. And that's what Menti stands for. Menti applies that to interlocutory orders and says, there's no reason to choose either or. You can file both. You can file them concurrently. You don't have to, but as long as you file your request for permission to appeal within the 30 days of the order that offends you.
But that's not what 1311 says. I mean, I think which is the anomaly that your opposing counsel has argued. He's looking at a freestanding rule that says you have 30 days from the date of certification.
Right. Case law is also legion that says a motion for reconsideration, a denial of a motion for reconsideration is not an appealable order.
But that's not what he's appealing from. He would say, I'm filing an appeal pursuant to the 30 days I get from the date of certification of the issue.
I don't remember that has ever been the rule.
Yeah, I'm not, yeah, well, I agree, I think we may be in new ground, but again, and I'm just reiterating what Justice Don is saying to you, and I understood the law as you understand the law, and he loses. Sure. But what he's saying is if you look, he has an order, it's undisputed, from the trial court that certifies him, provides him permission to take an appeal under 3111A. And looking at the language of 3111B, and I don't know that you have it in front of you.
I have a shorthand version.
Well, it says, permission to appeal from an interlocutory order listed in paragraph A, and he has that, may be sought by filing a petition for permission to appeal with the prothonotary of the appellate court within 30 days after entry of such order. And what he says is that nobody's ever looked at that carefully, but under that precise language, he gets a new clock if he gets a 3111A certified order. And that's the issue you're confronting, I think.
Okay. Excuse me.
Well, are you just to follow up the Chief's question, are you maintaining the trial court lacked authority for the October 8th order? The 30 days having run?
Yes.
That's what I thought you were.
The original order from the trial court that denied defendant's omnibus pretrial motion, that included the habeas corpus that we're talking about, was July 17th, and the 30-day clock began to run there. And it was only 4 days after that that McClellan came out, and McClellan, the issues in McClellan have been contemplated all through this
Well, even
matter.
so, even contemplated or not, the point is the clock started ticking That's why I asked my question, because the chief put the certification date in there, and I didn't think you're buying into that, right?
Correct. We're not buying into that.
Perhaps the argument again, and we'll figure this out later, we don't get to caucus on the bench, but maybe what Justice Wecht is saying to you is he doesn't have a 1311A order because the time had already run. Therefore, 1311B is inoperative and he loses.
Wait, but how
And
many,
I'll shut up.
how many days passed before he filed the motion for reconsideration?
The motion for reconsideration was filed on August the 11th of 2020.
Counsel, help me out on this. And this gets back to Justice West's questions regarding the trial court's authority. Are you saying that after the 30 days from the date of the entry of the original order, regardless of when the motion for reconsideration is filed, the trial court only has authority for 30 days after the entry of that original order to even grant reconsideration?
Yes. It's a jurisdictional thing. It
Well, it's not
also,
a jurisdictional thing, it's a
No.
power thing.
Yeah.
They never lost jurisdiction. It's a power thing. They don't have the power to certify.
Isn't that consistent with 903,
yes,
time for filing appeals?
Yes.
Within 30 days after entry of the order from which the appeal is taken?
yes. The only difference between 1311 and 903 is in 903, there is a note below the rule that explains you can file them both. But that's the only difference, and it's not a difference in the rule.
Well,
It's a difference in the note.
Under those circumstances, when would the 30-day period articulated in 3111B come into play? Why would there ever be a new clock if you always go back to the date of an original order?
That's precisely our argument. There is no new clock.
Well,
And the
then what
risk for the risk for mayhem that could be introduced into the system because there is on an interlocutory, in a motion for reconsideration, there's no time limit. On an interlocutory order, there's no time limit.
No
So-
time limit on what?
On filing a motion for reconsideration.
Okay.
So defendant could theoretically file a motion for reconsideration on an interlocutory order the morning that we're picking a jury, and the judge denies it immediately. But now we have a jury potentially sworn in, and defendant files for an appeal.
Yeah, but that's not what happened here.
True.
But it didn't happen here because of the timing, but it also didn't happen here because the judge then certified the order.
True. He didn't.
So my question is, why would there be a 3111B that sets a 30-day clock to file an appeal from the date of certification? I'm just trying to figure out as I sit here, if you're right on you always go back to the date of the original order, when you would ever get to utilize this new 30-day clock from the date of certification.
You're saying you wouldn't, right?
Right. We don't accept that there's a new 30-day clock.
Well, what is that? It says from the order. Justice Bear read it a few times. It says 30 days from the date of the order pursuant to A.
Right. And
Yeah,
Right,
I think it's the 30 days. Again, I think the procedural, I think this case really comes down to was whether this was an order denying reconsideration. Because if it was an order denying reconsideration, which is not appealable anyway,
Right.
then all of this stuff about certification doesn't really matter because the trial court can't certify for interlocutory appeal an order that is not appealable at all.
you understand the Commonwealth's position exactly.
Okay.
Mr. Sotis, I apologize. We never let you make a statement. I think I was remiss in that. We're all good lawyers, and we're all brain teased by an interesting procedural
Right.
quagmire.
I understand.
So before you sit down, if you would like to take a couple of minutes uninterrupted, I'll give it to you. If we understand the question, then there's no need.
I think you understand the question, Your Honor. The Commonwealth would like you to uphold the decision of the Superior Court that applied Menti.
We appreciate your indulgence in playing the hypotheticals.
Okay.
And you didn't didn't drive all that far, Cumberland County.
It was very early in the morning, though, and I did not have coffee when I did it, so.
Thank you, counsel.
We appreciate it because had you attempted to argue further, we would have interrupted again anyway.
Wouldn't have mattered, right?
Very good. Thank you for your time.
Thank you. Thanks.
Thank you also.
Thank you.
You made it an interesting case.
Excuse us for still quizzing each other about the prior case. In 2004, I think I have the right case now, Brian. Did you call it? Yep, I got the right case. Thank you. Charlestown Township erected a zoning ordinance that permits advertising billboards in an area adjacent to the Pennsylvania Turnpike. 7 years later, the PennDOT constructed an interchange ramp onto the Turnpike. The department's regulations effectively make it unlawful to erect an advertising billboard within the area previously zoned for the billboards along the Turnpike by the township. Charlestown Outdoor has a leasehold interest in the portion of the property in the area zoned for advertising billboards, plan to construct a billboard on that property. It cannot do so because of PennDOT's regulations. Appellant therefore challenges the township's 2004 zoning ordinance, alleging that it's unconstitutional because it's a de facto exclusion of outdoor billboards. The zoning hearing board rejected the challenge. The trial court and the Commonwealth court both affirmed. We granted allowance of appeal again to hear the somewhat unusual scenario and see if we should make an exception or create law that's in support of the Aplt. So please feel free to go right ahead. You're Mr. Snyder?
Yes,
Thank you, sir.
Good afternoon, Your Honor, Chief Justice and Justices of the Court. The case is a little bit different than what you said in that...
Please correct me. That's why
yes.
we do this.
In this instance, you have taken jurisdiction on the question of whether, it's really two questions. Is the validity of an ordinance from a de facto standpoint, and by the way, I apologize, I forgot to introduce you to Mr. Feinhauer and Mr. Riley from our office. In this instance, you've limited it to two questions, partially because the Commonwealth Court didn't reach the third question. And those two questions are, is the validity of a zoning ordinance from a de facto exclusion standpoint decided at the time and only at the time the ordinance is enacted, without consideration of what happens in the future? And then, secondly, if you don't, and you can look at what happens in the future, can the actions of another governmental agency be the reason why the use is precluded where zoned? So those are the two things that I will limit myself to.
But that's the question, is like it brings up for me the question, what relief do you want? Because you're not actually asking us to do anything about PennDOT and its regs or its ordinances, and they're not a party.
No.
I don't, because that's of course what's precluding you from putting up your billboard.
What's precluding me from putting up the billboard is an ordinance of the township that permits billboards in a place where they can be built. the reason why they can't be built where the township initially provided for them is the fact that there's an intersection with setbacks that occurred afterwards from the standpoint of construction. You all know from the Supreme Court case that existed from 2020 or 2001 that the township knew it was going to be there in 2001 because they filed a case to the Supreme Court to try to prevent the interchange, and it was denied. So we know they knew it.
I'm sorry, just one more follow-up, sir. Does that mean, suppose you're right, and suppose they had some kind of obligation to update or to stay abreast of what PennDOT's doing, how would it work? Would their supervisors have to reconvene and pass a new ordinance or permit your billboards anywhere in the township, or what?
I think the MPC provides you with, the municipalities planning code provides you with guidance in that. In the realm of zoning, you have comprehensive plans and you have zoning ordinances. The zoning ordinances are meant to implement the comprehensive plan. The comprehensive plan has a requirement of updating at least every 10 years. So that if this township then learned of the issue, it would have in its comprehensive plan dealt with the fact that it's now not permitting that a legitimate business use can't be constructed in that township like Norate and all the cases following it would demand. In this instance, in 2008,
Mr. Snyder, I'm right where Justice Wecht is, I think. As I read this case in preparation for the argument, it seemed to me, and I certainly don't have the expertise in zoning that I'm sure you do, but it seemed to me that this ordinance was constitutional, and as of today is constitutional. The impediment to your client putting a billboard is PennDOT. And you need to get PennDOT to change its regulations, and then you'll have no trouble with the municipality.
well, let me go back and give you a little bit of history of this area of law. This area of law where there have been issues of an ordinance that permitted a use in a specific area, then not permitting them, have really, up until now, fallen into one category. They've fallen into the category of what are called saturation cases. The property in that zone has been used for other permitted uses. And the courts correctly have said that's not a reason why a township must now provide more land for a use that wasn't put in that zone just because it's been used otherwise. Part of that reasoning is land uses change, and that use could still be put there if something is, say you have a mobile home park. Mobile home parks often become something else over time. So that could be used for the use that wasn't built in the first instance. This is not a saturation case. The problem is the lower courts, both in the Court of Common Pleas and in the Commonwealth Court, treated this as a saturation case. They said they used, the cases they cited were the three main saturation cases. And they never dealt with the issue of this is not the situation where that use can occur later.
So you would like us to remand?
Well, yes, you would have to remand because there's still one potential defense that was by the township that wasn't handled below. So it would have to go back. But let me give you 3 examples of why, Mr. Chief Justice, I think your analysis is wrong now and particularly for the future. Because these are 3 instances. 3 instances.
I appreciate it.
Yeah.
I'd like to get it right. Go ahead.
Yeah. 3 instances where there's not a rezoning, but there's still the inability to place that legitimate business use in the township. First picture, a situation where there's 2,400 feet between two intersections, and the township permits the use in the area between them, and has a 400-foot setback from interchange. And yet, over the next years, and by the way, this ordinance wasn't passed in 2004, it was passed back in the 1900s. It was just the name of the district was changed in 2004. So this is a use that was permitted only in this place for a long time. We're now.
The use was there before the turnpike was there, ironically.
No. Turnpike was there in 1937, so no.
When?
This is
The oldest.
37.
But I said this was passed in the 1900s, after 1937?
Oh, yes, this was, I'm
Okay.
sure it was passed in the 1990s, maybe 1980s. We don't know from the record. But taking my example, over the intervening years, 2 new roads come in, each 800 feet apart. And now, the township's ordinance by itself, even without there being a new enactment under that ordinance, you can't build the use anywhere in there because of the setbacks. One example. Another example, you have a property where there's a stream running through that property. In 1976, we passed the Clean Streams Act. In 1986, we start enforcing setbacks for wetlands. In the 2000s, we create classification of streams and state regulations for setbacks from streams. So now, if it's an exceptional value waterway, you now have 150-foot setbacks that, when taken with the other setbacks on the property, preclude that property from being used for that use, and it's the only place in the township that's zoned for it.
So is the principle that you're trying to get us to focus on distinguished from the land saturation cases that deal with uses? You're talking about a structural change to the municipality that affects the zoning, not a use change, but some sort of a
Structural change relating from some other governmental agency.
But not a use.
But not a use.
A highway exit ramp is not a use. A wetlands designation is not a use.
That's
It's some other, that's how you differentiate it from saturation case.
That's correct, and that's what the court below and the lower court and the township in its brief specifically argue, that this is a use. The interchange is a use of land like building townhouses. It's not, it's an intersection. It's an intersection that, because of the limited access, has larger size. But
It's not the intersection that creates the problem. It's the PennDOT regulations regarding the outdoor advertising that causes the problem around the interchange.
It's the PennDOT regulation of setbacks from a safety standpoint of what's safe with its intersection. Just like in my first example, the township might have had a setback for signs of 50 feet from intersections or 400 feet from intersections. It's a valid governmental regulation.
Isn't this a perfect example of something the General Assembly should take a look at?
But the General Assembly
Through this court.
the General Assembly has.
Well, but
And that's why,
that doesn't mean that we should. I
No,
mean, it just
but-
means they should.
no, what I'm asking you to do is correct the lower court's failure to apply the principles that are in the municipality's planning code. The municipality is supposed to take into consideration consistency with other governmental regulations and acts.
At the time, sir, in other words, your case would be different if they switched the ordinance on you and made your use illusory later. I thought the chronology was that they had the ordinance, and that after this thing was already up and swimming, then PennDOT switched up on you. Isn't that what happened?
No, the PennDOT regulations have been in effect since 1970s. So that this isn't something,
The building of the interchange was much more recent.
the building of the interchange was much more recent. the consideration of it by the township was not, the township argues that 2011 is the date. No. Part of the record is their comprehensive plan of 2008. Their comprehensive plan of 2008 makes a specific statement of making specific recommendations as to land use changes in the zoning code of the area of the interchange. That's on page 2-14 in section 2.3 of their own comprehensive plan of 2008. We filed our challenge 9 years later because they did nothing. Knowing the problem, they did nothing. So in essence, that lack of action is in fact action.
Was that a scenario? Was there a fact finding as to whether that was a done deal at that point, or was that just a projected scenario?
That was the adopted comprehensive plan. That was a statement of what they were to do under that comprehensive plan.
Under what circumstances?
It identified the fact that the interchange was occurring in DeVault. That's the intersection of Route 29 and the Turnpike. And made a specific recommendation to review the existing zoning regulations for modification because of that construction of the interchange. Now, in this instance, you have a different situation than just, I agree with you that if they learned on Tuesday and we filed a challenge on Thursday, that shouldn't occur. But here you had action by the township. The action of the township was the inaction, knowing that they now no longer had a place where a billboard could be built.
I'm confused by this argument, or maybe I didn't understand it in the briefing when I read it, or maybe I just missed the point, but, I mean, you're saying that you're here because they failed to follow their comprehensive plan.
No, I'm saying I'm here because there is now no longer a place in this township in which to construct a billboard. And it's there 9 years after the township took action to say what it needed to do to cure that problem. So I think their inaction has created the prohibition.
Well, but their point is that they weren't required to act at all.
No, they are required to act.
No, but their argument is they are not required to change their zoning ordinance that was lawful before the act to then remedy the act of a third-party government.
I disagree. And
Well,
I disagree.
you disagree that that's their argument, or you
No,
disagree with their argument?
I disagree with that legal principle.
Okay.
And I cite to you section 600 of the MPC, and I cite to you section 603. One says that the zoning ordinance, the purposes of the zoning ordinance is to implement the comprehensive plan. Now, we know they passed the comprehensive plan in 2008 saying that they had to make changes in the DeVault area because of the interchange. Secondly, section 603 says that the zoning ordinance is to be generally consistent with the comprehensive plan.
Okay, so let me see if I could clarify one more time. You're not asking for a general principle of law here. You're asking us to consider the circumstances of the comprehensive plan in this particular case that anticipated the occurrence that created the exclusion of this use, and the fact that they did nothing to follow their comprehensive plan.
Almost.
Because that's a very different case than we took on a general, you know, on
Sounds
the.
a lot like error review.
Yeah, I mean, that's a very different case that I understood that we had sitting here.
Let me correct something. The Commonwealth Court, up until this case, had never said, and in fact had said particularly, we hold that the validity of a de facto exclusion is not simply determined at the time of the enactment of the ordinance. This case, for the first time, held the opposite, held that it is. And that's the error, that's the issue that is brand new for this court, the differentiation of that rule within the Commonwealth Court. And the reason why that rule shouldn't be simply, it's de facto, is determined at the date of enactment, is that that enactment can be 40 years earlier. The whole world can have changed. The regulations can have changed. The MPC provides that zoning ordinances should be consistent with and compatible with the zoning, the regulations of the other acts and regulations of the Commonwealth and that are federal.
May I ask you, could you have brought a mandamus to compel them to change their zoning ordinance to conform with their concrete plan?
I don't know that, Your Honor. The MPC provides that this would fall under 916, which is the validity challenge to the ordinance. The issue of compelling them to pass an enactment, I think, would be a much different. I think I'd be here on having been turned down on the way up as to how I got there.
You're probably right. One of the things that bothered me, one of the reasons I was sifting for that remedy, almost as if I was sitting in your law office, is when between their comprehensive plan and the passage of time does it become de facto unconstitutional? 6 months, 6 years, 16 years?
Well, I don't think it's 16 years because those changes in the comprehensive plan are every 10 years. In this instance, if you look at the timeline, Township knew at least by 2000 that the interchange was coming. The 2004 date was simply a change in the name of the zone. So we're talking about something that was passed really before that. In 2008, they entered this joint comprehensive plan that identified the interchange and said that they should be making modifications to zoning in that area. In 2011, the interchange actually went in, and in 2017, 9 years later, is when we filed our challenge. So I don't think that may be a question for a case that's less clear of inaction, but this one is very clear as to inaction by the township.
I ask you two additional questions. First is that they're going to argue, obviously, but one of the things they put in their briefs was that if we impose this burden on all the municipalities in Pennsylvania, it's an impossible one because, as you said, DEP comes out with regulations, gaming and fishing come out with regulations, fire and safety come out with regulations, the Turnpike has regulations, as it turns out. So every time government, using all of your hypos, changes the circumstances in a municipality, the municipality is going to have to respond to make sure that the underlying purpose of their zoning act is consistent with reality.
Absolutely. That's their obligation under the law. They're supposed to be consistent with those. The idea that it would be expensive and a burden on them is a red herring. They have planners. They have engineers. They do their comprehensive planning. They find and know these things. That's why I'm saying maybe they don't know it the next day, but certainly in their planning process, they know it. And it's not an economic burden because these people are already doing that.
Right.
There's no reason why they would have to, as alleged in their brief, know the impact on every individual piece of property. They need to know how it impacts their general zoning. And in this case, it precluded a use that was a legitimate business use.
Let me ask you one last question, which we've not addressed. An alternative argument is that your client, well, not your client, I'm sorry, the municipality is part of the Phoenixville Regional Comprehensive Plan, and under 9161H of the MPC, if you can put up a billboard somewhere within the communities that belong to the comprehensive plan, that cures your objection.
I
Why is that
understand,
wrong?
and that was the issue that was not reached by the Commonwealth Court. I'm happy to tell you what our very clear answer is to that, but it was the issue that was specifically precluded by your acceptance of this case, because it would have to go back to the Commonwealth Court on that issue.
Evidentiary hearing, doesn't it?
No, it doesn't require an evidentiary hearing. The reason why it doesn't apply is already in the record, and that
Why
is...
don't you tell us, because we always are concerned with
Okay,
judicial
that's-
economy.
Okay, that's their comprehensive plan. Their comprehensive, the 916H says, first of all, it requires ordinances to be consistent with the comprehensive plan of all of the 6 municipalities here. Secondly, it exempts you from the requirement to take every use in your municipality, every legitimate use in your municipality, if there's planning by that multi-municipal group that allocates those places in places within the 5 municipalities. For example, you'd want to put apartments where there's water, sewer, roads. If one of those municipalities is rural, it may not be the place to plan apartments, so it may get exempted from the requirement under 916H of having apartments as a use in there. That's because they've multi-municipally planned that use. In this instance, their comprehensive plan, their multi-municipal comprehensive plan, never even contains the word sign or billboard. There was no multi-municipal planning of where billboards should be. So to be exempted under 916H, they should have planned that use. That's our argument with respect to it. Otherwise, you get to the situation where they come in and they plan billboards and now say we're exempt for apartments. If they don't plan it, 916H shouldn't apply.
Well, if it's so clear-cut, why are you requesting a remand then?
We're not requesting a remand. It was never handled by the Commonwealth Court. In my petition for allowance of appeal, I raised both questions. This court only accepted it specifically on the first question and not the latter, I think because the Commonwealth Court hadn't reached it. I would have loved you to have taken it on both.
All right. It was a limited grant. You're absolutely right. Thank you.
Thank you.
Mr. Withers?
Thank you, Mr. Chief Justice. Good afternoon. May it please the court, Scott Withers of Lamb Macker Lane, on behalf of the appellee in this matter, the Charlestown Township Board of Supervisors. I'm joined at council table by my law partner, Mark Thompson, who was trial counsel. The argument that the comprehensive plan being amended when it was and giving the township a duty to then zone another area puts the rabbit in the hat, Your Honors, because that argument assumes that there was a de facto taking by the township when the regulations were passed by the state and the slip ramp came in, okay? If we go back to first principles, at its essence, the appellant's claim here is that the Charlestown Township has deprived Outdoor of its property rights without substantive due process through a de facto taking, okay? Our ordinance doesn't deprive them of anything. our ordinance, which was established long before this case, and as you mentioned, when it was amended 7 years ago, that was just to change the names of the zoning districts, put billboard use in the best place possible in this little rural township, on the only limited access highway there was. Very good place to have this, economically feasible for a billboard owner. Subsequently, the slip ramp comes in, and it's the slip ramp and the regulations in the PA code and in the Outdoor Advertising Act that preclude building billboards within the area previously zoned. Now, another fact that we have to consider goes right.
Respectfully, their response is that imposes now on you an affirmative duty to do it elsewhere.
In other words, that was a de facto taking by us that we now have to remedy.
Well, regardless of where you would assign fault, I think Mr. Snyder would say that's irrelevant. The circumstances are such that they can't build a billboard, and that's a de facto taking. I think that's what...
That's their argument. And then another thing, Justice Weck, you asked what relief do they want here. Now, we have to go back to the facts to understand what relief they want. Outdoor is not does not have an equitable interest in any of the property that was previously zoned, or that is currently zoned for billboards. All of that area has been rendered unusable for billboards because of the slip ramp. Outdoor owns another piece of property, Justice Weck.
In the same township?
In the same township. And on the basis of that equitable interest, they have filed their action before the Zoning Hearing Board, and they're going to eventually request site-specific relief to put those billboards up right next to a residential neighborhood. So that's important to know, and that answers your question. There is no de facto taking here because...
I'm sorry, just on that, sir.
Yeah.
Would that violate any township ordinance as it exists currently? Were the billboard to be placed there by the residential?
We haven't looked at that. There hasn't been a building permit or an application to put that there. I think those issues would probably be vetted were this court to remand and say they could get site-specific relief.
But that would be the relief that, if they won, so to speak, that they could get, hypothetically.
I understand, yes.
And by the way, what's your response to opposing counsel's argument, appellant counsel's argument, that, as I take it, the township was well aware of the turnpike plans or the PennDOT plans?
On this record, all you've got is what's in the municipal plan, where clearly there's a section of the municipal plan that says this needs to be looked at. But if we view this, as the township does, as a saturation case, this is akin to a saturation case. If we zone for a particular use, and the owners of all that property where that use is allowed put in a different use, we don't have to then, because it's been saturated, that we don't then have to now enact a new zoning district that allows the use that has been saturated, or the ground that's been saturated preventing that use, to occur in another place.
But there wasn't a use, Mr. Withers, there wasn't a use here consistent with your zoning ordinance. There was a taking. There was a taking of property and an easement, or whatever you want to call what PennDOT did here. So it's kind of hard to analogize it to a saturation case where the saturation was an actual use according to the zoning ordinance. Let me give you a different hypothetical. Let's assume that a municipality zones for signs, billboards, on the edge of the municipal boundary, in a district that's on the outside of the municipality, not in the center, but right on the outside bordering with another municipality. And due to a fight, there is a redrawing of the municipal lines by a court of common pleas, by statute. Court of common pleas redraws the municipal line to now put that area into a different municipality. So that use is no longer allowed in the municipality because that line has been redrawn to take the area and put it in a different municipality. Do you have to rezone?
We don't have to, but we have a problem if we get a challenge.
Okay. Why is that any different?
Because when that happens, and the municipal line is redrawn, there's no argument to be made that the township didn't know that was coming or wasn't, or shouldn't have known at that point that it had to change its regulations. In this case, I don't believe it's all that clear that the township actually knew that that slip ramp was going to go into the location it went into. In fact, I believe, and I don't believe this is part of the record, but I can tell you as an officer of the court, that in the challenges that Charlestown did to this turnpike, they, just like any time PennDOT does something, they had something like 7 different plans of what they were going to do. So there were 7 different options for this slip ramp. And so on this record, I don't believe it's clear that the township knew that all of the available land for this use, Justice Brobson, would be no longer available by virtue of the pending construction of a slip ramp that's exact and precise location hadn't been determined.
Mr. Withers, could you explain or give us your reaction to this suggestion by your opposing counsel that there is kind of a global obligation, affirmative duty throughout the Commonwealth for municipalities, solicitors, or engineers, or whoever you have access to become informed on a continuing regular basis of changes in regulations by whatever agency?
You know, Justice Todd, the adoption of zoning regulations requires significant planning to determine where and to what extent certain uses should be permitted. The process typically involves paid consultants, land planners, solicitors, people who ensure in making sure that the zoning ordinance, when adopted, complies with those regulations and anything else levied by the legislature. And that usually takes place.
What about in the middle?
And that's where we are. So there's a statute. The MPC requires them to look at their comprehensive plan every 10 years. 53 PS Section 10301C. There's no such requirement to do what you're describing, and we make that as a I'm
describing what he described.
Yes. Justice Todd, yes. There's no such requirement, and that the legislature knew how to make that requirement for comprehensive plans every 10 years means they could have required townships to do this every year to make sure that they're that this kind of situation hasn't occurred and that there doesn't need to be an amendment to the zoning ordinance.
But doesn't the MPC already build in sort of a notice process in the case of a de facto taking? They initiate the process administratively, and you always have the opportunity to do a curative amendment or to amend your ordinance when you get notice that something like this happened. So you don't have to have this omnipresent prescience about what is happening by different governments, because the landowner will initiate the process, and you have an opportunity then, with notice, to do a curative amendment.
If there was a de facto taking.
Well, obviously. But I'm just saying this idea that you have to be somehow this proactive, watcher of multi-government agencies is really, the MPC provides notice to you.
And maybe prospectively in the future, if this court were to hold that this situation where the state comes in and makes the regulation results in me as the township committing a taking, a de facto taking, when I didn't do anything.
Well, you sound so offended by that. They're not accusing you of a crime.
But at its essence, let's go back to Surik. Surik's claim was that the township developed an ordinance that restricted his use of his property and therefore was a de facto taking. Our ordinance does no such thing. It's somebody else who comes in, and it's another third party.
Yours is an alleged passive de facto taking, whereas there are some municipalities that hire really good lawyers and craft very carefully worded ordinances to effectively zone out something. The billboard cases is a perfect example where they limit the size or they limit how far it can be from something. This is more of a passive de facto taking. I don't think they're accusing you of any wrongful conduct. It's just it just happened, and it didn't happen because of you, but it's something that they're saying has to be remedied.
If this court then says that de facto taking is my responsibility to remedy, then the duty arises. But Charles, why would the township, when there's no such law, there's no such case from this court that says the township is the de facto taker when an intervening third party passes another regulation, for me to change the ordinance when I might not have had to?
Mr. Withers, would it be fair to say that one of the prime distinctions in the positions here is that Mr. Snyder went to great lengths to say this is not a saturation case, somewhat conceding that if it was a saturation case, he would not prevail because the law is well settled, and you're saying this is a saturation case?
It's the closest thing we can analogize to.
You can't claim that it is, but you're saying it's akin to.
Exactly. This clearly isn't a saturation case because that saturation it didn't happen here. It was the intervening action of the state and the construction of that slip ramp.
Mr. Withers, would it be your same position if the example of the use was changed? For example, what if this area was marked for low-income housing and then PennDOT came in and put the slip ramp in, and now there's no area in your township for low-income housing or multi-family housing?
That would be saturation, I think.
Still.
I think that is saturation because that is not, the turnpike coming in and putting the slip ramp in means that the owner of the property in which that low-income housing was permitted pursuant to zoning had done something else permitted by the zoning ordinance instead. And therefore, that area had become saturated, and we don't have the duty. And so if viewing this as a saturation case, we don't go change the ordinance. If it's a de facto taking, then every township is going to have to be doing that.
I have one more question.
Yes, Justice Mundy.
In your brief on page 7, you say a township is not required to update its zoning ordinances every time an intervening condition not caused by the zoning ordinance may prohibit the development of a property for another use. And you don't really cite an authority, and from what I'm gathering today, it's the absence of authority to the contrary.
And I believe that's why we're here, because I think that is an issue of first impression. And there's no authority that required us to do that. Prospectively, if we're required to, then that's what we'll have to do.
Counsel,
Yes, Justice Dunn.
I asked your opposing counsel this question. Is this a situation that calls for a judicial remedy or a legislative remedy? When you have conflicting governmental regulations that impact the land use?
Well, on this case, representing this township, I want it to be a legislative remedy because the judicial remedy is not palatable to my township. So I would want the legislative remedy. I don't know what that legislative remedy would be.
What is a palatable remedy?
Well, we'd like you to affirm.
No, but I mean, what's the palatable remedy? If you were,
A palatable remedy?
if you were us, I mean, somebody is sitting here saying, here's what
My
happened.
co-counsel and I were discussing that on the way up. I mean, what does it, maybe the township gets a grace period to go and to do some sound land planning and determine another place in the township that billboards would be feasible, etc. But I don't know where that's making up a remedy.
Did Mr. Snyder respond to that you've had 9 years?
Well, if we knew this was a de facto taking that we had to remedy back when the slip ramp was in, okay, but that's what I mean. That puts the rabbit in the hat. We don't know this is a de facto taking back there, and it's surely not a de facto taking by us.
And if it's
my
not
argument.
a de facto taking, you prevail, and they have no remedy because they have no right. Is that fair?
Yes, we affirm the Commonwealth Court.
Whoever said zoning cases weren't interested.
But if this court does reverse the Commonwealth Court, a remand to the Commonwealth Court to pass on the 916.1H
Right.
issue is necessary, because the trial court, they did pass on that. The trial court concluded that the zoning ordinance for all the participating municipalities were generally consistent with the regional comprehensive plan, and the trial court found that the zoning hearing board's determination in that regard was supported by substantial evidence. So if this court reverses, we need a remand to the Commonwealth Court to consider the MPC 916.1H issue, which they did not address in the first place, and had they addressed it, it would have been dicta. But it would have been dicta that you could have affirmed on any basis for.
Thank you.
Thank you, Your Honors.